make sure all cell phones are on silent. Court open. Hey. All persons having anything to do before the Honorable Justices of the Appeals Court, now sitting in Boston within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. And wow. Welcome to the September 10th, 2025 sitting of the Massachusetts Appeals Court. I'm Justice Eric Neyman. To my right is Justice Joseph Ditkoff. To my left, our friend, Justice John Englander. Today is a special sitting of the Appeals Court, as today is the last official sitting of Justice Englander. Per Appeals Court tradition, that means that not only do all of the judges attend, but also the panel members will make a few brief remarks. Before we begin, I would just like to address a couple of housekeeping matters. First, there will be a sitting in courtroom 3, which will begin at approximately 9:45. Secondly, I would like to acknowledge some people here today. Justice Englander's son, Will be here shortly. I would like to acknowledge... Don't go there, Dad. I'd like to acknowledge Justice Englander's current and former law clerks who are here today. And of course, I would like to acknowledge Justice Dalila Wendlandt from the Supreme Judicial Court, formerly of the Appeals Court, former crypt mate of Justice Englander. And also, it's great to see our colleague, retired Justice Jim Milkey from the Appeals Court. So without further ado, I turn the floor over to Justice Ditkoff.
Well, we are all going to miss Judge Englander, and more specifically, his premium Red Sox and Bruins seats are really nice. We will not miss his printing out every document he receives, single-sided, or his handwritten edits, which he then takes a photo of and texts to you. Judge Englander came to us from the Department of Transportation, and I think his approach to technology gives you some insight into the T's troubles. Seriously, though, right before Judge Englander came into my chambers and told me he was leaving, I was actually sitting there telling my former law clerk that I believed with just a little more time, Judge Englander would be the best judge on this court. That's really what was happening. But I hadn't realized how little time he had left when I said that. Judge Englander is a good friend, he's a respectful colleague, and has the most important characteristic a judge can have. He's someone who listens to what others say, judges, attorneys, clerks, staff. He's a listener. But what makes Judge Englander so special is that he thinks more deeply about the whys of our jurisprudence and even the entire business of judicial decision-making than any judge I've met. We're not generally a court that thinks a lot about first principles, but Judge Englander always does. Of course, as an intermediate appellate court, we have to follow the law as set by our betters, but sometimes that means we don't ask why the law is the way it is. And sometimes that means we miss the forest for the trees. But Judge Englander is always asking why and how the law developed. And that often yields profound insights about where the law should be going and how it should be applied. Without Judge Englander, I really believe we will be a poorer court, a less thoughtful court. Judge Englander may have mentioned once or twice, or maybe more times, that he clerked for Justice Rehnquist at the Supreme Court. He followed that with 30 years of productive and lucrative work at Goodwin Procter. But, and I think this would have done the great Chief Justice proud, he gave that all up for public service, first at the Department of Transportation and then here at the Appeals Court, in the old tradition of giving back. We are grateful for that, but more important, the people of Massachusetts have been enriched by that decision he made. In the Jewish tradition, we have a blessing for the first time you do something, but there's no blessing for the last time you do something. I guess that's because you never really know it's the last time, but today we do know that. So let me say this as sort of my blessing. I know our relationship will continue, so I don't expect to get the chance to miss you as a person, and I'm grateful for that. But I will miss you as a judge very much, and I think I speak for all of our colleagues in saying that. There's a tradition in the appeals court of allowing a judge to choose his last panel. At first, I was incredibly honored to be chosen by Judge Englander, but then I thought about it, and I realized he must have chosen Judge Neyman because they both went to Cornell and love Cornell hockey. And then I thought about it, and I haven't asked, but I'm pretty sure I was chosen because Judge Englander and I, alone of the appeals court justices, share a heritage from Buffalo, New York. So I'll just conclude by saying, go Bills.
Thank you, Justice Ditkoff. This one's difficult. Justice Englander came to us about a decade ago, and it is no exaggeration to say that he is among the most proficient, prolific, and influential justices in the history of the Massachusetts Appeals Court. As far as I'm concerned, John, you're leaving us much too early. We shouldn't have been surprised that you were so prolific in view of your background and your reputation. You came to us with quite a hefty reputation. On the one hand, you were pursuing a career in the law, and on the other hand, you had a degree in engineering from Cornell. You rose to clerk for Justice Rehnquist at the U.S. Supreme Court and became head of litigation at Goodwin Proctor, and yet you were a nationally ranked tennis player. You hobnobbed with Hollywood types and Wall Street mavens, and yet you are most at home in the stands at the hockey rink at a Boston Bruins game. I think in the old days we would say that you are a modern Renaissance man, and there is truly not much that Justice Englander cannot do except turn on his computer and respond to emails without hitting reply all. But today we're not going to joke at Justice Englander's expense. We are not going to poke fun, for example, at his age. I'm not going to say, as a Renaissance man, John, what were, Da Vinci and Copernicus really like in person. We're not going to do that. Nor are we going to poke fun at your technological capabilities. The fact that you refer to your computer as that infernal machine. The fact that you eschewed for a decade the use of an iPad in favor of a quill pen, inkstand, and parchment paper. But Justice Ditkoff and I did decide that we are going to leave you a parting gift that is befitting of your legacy. As many of you know, our data retention system known as LiveLink is being replaced in the next year. And Justice Ditkoff and I are filing a petition with Chief Justice Blake. And please think of this in terms of legacy. We ask that the new technological platform be known solely as Englander. Please work with me. Think about this in terms of legacy, imagining years down the road, judges and staff attorneys and clerks wandering the hallways of the appeals court, muttering under their breath things like, "Englander's down again." "I just can't get Englander to work." Englander is so arcane. I mean, the possibilities are limitless. So now comes the difficult part, John. We thank you for being an amazing colleague. You have spent countless hours not just working on your own opinions, but spending nights and weekends working on first and second panel, ensuring that our jurisprudence is where it should be. You have been a precious resource and mentor to many, including myself, and we are going to miss your advice, your wit, and your wisdom. You have been a voice of reason on this court. You have been a passionate teacher of the law, which in my view is the very best trait of the very best judges, and you brought that each and every day to this court. And most importantly, John, I'm going to miss your friendship each and every day. So today we applaud Justice Englander. We thank you for your dedication to this court and your impact on this court and your impact on the Commonwealth of Massachusetts. Thank you, John. And now for those who do not have business before,
Oh, I don't get to say nothing?
well, there is no rebuttal, but if you would like to make a few remarks, sure.
You know me, there's no opportunity to say something that I won't at least take some opportunity.
I'm glad you made that
Give me
decision.
a moment, please. Give me a moment. Yeah. Thank you to that boy, the person you just described, someone who I'm not familiar with, to paraphrase Ben Hogan. But thank you to my crip mates, Judge Neyman, Judge Ditkoff. As many of you know, I didn't grow up practicing criminal law, but as luck would have it, I was provided with adult supervision. And so the carpet between my office and Joseph's and Eric's is well worn. I would get up, walk across the hall, or turn right, walk down the hall, and that was incredibly helpful. My work was far better than it would have been had I not had the benefit of their knowledge and judgment and counsel, not to mention their friendship. And the same goes for my other colleagues on this court, present and past. What an abundance of talent I was fortunate enough to work with. This is an excellent court. When I was a young lawyer, I worked with two other excellent courts, appellate courts, and I recall Judge Aldrich saying to me at one point, what I most should understand about the First Circuit as it then existed, that regardless of our differences, quote, we are all dedicated to getting it right. And I think I found that to be fundamentally true of this court as well. Very quickly, folks, thank you for coming. Thank you to my law clerks, several of whom are here, and to whom I owe much. To my administrative assistants, Jeanette Corbin and Kelly Polizzotti. Thank you to the court staff, too numerous to mention. But please know I appreciate you all greatly, even when I quibble with your edits or wrestle with your recommendation in a single justice matter. Thank you to the two chiefs that I worked for, Mark Green and Amy Blake, and to my good friends now, the two most senior judges, Bill Meade and Ariane Vuno. And thank you as well to Dalila Wentland and also Scott Kafker, who's sitting downstairs, who both helped convince me to come here and then went on to bigger things. You've mentioned Justice Rehnquist, and very quickly, he was an example to me, not just because he was a great judge, and he was a great judge, but because he was a great colleague to everyone on his court, regardless of their ideology. And that's well documented and well known by everyone. And I tried to emulate that. And I think I fell down on that probably too often. But I think it is something that marks this court, and I know it will continue when I am gone. I've had a blast, and I will miss this place greatly. Thank you. So much for no rebuttal.
I'm afraid to say it. Now, anyone who does not have business before this court may leave the courtroom. Session will start shortly in courtroom 3. Thank you. Calling our first case on the list today, docket 24P825, Commonwealth v. Lewis. And we will hear first from counsel for the appellant.
Good morning to the panel. If it may please the court, I am Attorney Ian Kahanowitz for the appellant. Today we are here because of a situation that occurred in Walpole back in 2019. My client was driving from pretty much the Boston area into Walpole to go meet a friend. On the way there, she stopped her car at a tire company and basically tried to read her emails, text a few friends. She thought she was lost. She fell asleep in the car. And 2 people had witnessed that. One was the service manager, who saw that the car wasn't parked directly in one space, but a few spaces, and a pedestrian who was coming to get her car at the Town Fair Tire that day. Police were called. Police came onto the scene, and what was supposed to be what was called a wellness check to see what's going on with my client ended up being a full-blown search and seizure. When the police came, they saw my client slumped over, sleeping. They knocked on the window. They proceeded to wake her up. When she woke up, there were reports in their police report, and my client was glassy-eyed. She was stuttering, and it took her a while to understand what was going on.
So your contention is that something that was done here was unreasonable, right?
Correct, Your Honor.
What was unreasonable about what the police officers did here?
So normally during a wellness check, it's pretty much to see if the person inside the vehicle is okay. It's a less intrusive check than having a investigatory check whereby you have more constitutional rights to privacy. Here what happened was the police knocked on the door, on the window. Then the officer ended up opening up the car door, putting his hand in, turning the key off. There was nothing wrong with the car. The car was, yes, it was running, but it wasn't driving. It wasn't.
So it was unreasonable for the police officer to turn off the car that was running with someone sleeping in it?
I do believe so. It could be for anything.
Okay, and what did that unreasonable act lead to?
And what that led to
I mean, what's the fruit of that unreasonableness?
well, the unreasonableness is this. There was no probable cause to think that a crime was being committed to begin with. And when they asked her to step out, they smelled alcohol, which again, it was not indicative that she actually drank.
Was it unreasonable to ask her to step out?
At the time, I do believe it would be, because
I mean,
again, if,
even performing a wellness check, why would it have been unreasonable under the circumstances where she had to be roused from sleep? She'd fallen asleep in a car that was running, parked in an area incorrectly. Why would it be unreasonable for them to ask her to step out?
the police contended that part of the car was blocking the entranceway. And so what they contended was, well, something's wrong here. And they didn't like the fact that she had signs of being inebriated. She had glassy-eyed, slurred speech, and it took her time, basically, to open the door, well, the lock, and then the police decided to go into the car. The problem was here is that the police should have just, if it was a wellness check, knocked on the window, waited for my client to answer, "Are you okay?" Yes. There was an ambulance there to prove that it was a wellness check. Normally, if you have an investigative probe into a car that, maybe you think is alcohol, you won't have a.
I mean, I'm quite serious. I'm having difficulty with establishing through your argument what they did was unreasonable. Okay, they did, yeah, I guess they called an ambulance, right? They have somebody
did.
who's asleep during the day in a car parked in a funny way in a business. So they think something's wrong. I mean, is that an unreasonable view? I mean, that's an odd thing, right? For somebody to park their car in an odd way in a business where they don't belong, leave it there running, and fall asleep. So what did they do that they shouldn't have done?
So that's what I'm contending here. What was so wrong what she did? She fell asleep in a car. For all we know, there could have been someone she was waiting for. There was no signs of drunk driving. There was no movement of a car.
Well, wasn't the car parked in a manner, I know that this was contested, but according to the judge's findings, in a manner that it was blocking the entryway to Town Fair Tire?
And that's where it gets hazy, where the police officer.
That's the judge's finding, and my understanding is, from your brief, is you do not challenge any of the judge's findings as clearly erroneous. You're merely challenging her rulings of law, correct?
Correct.
So the police approach, they receive a call for a person unconscious. They find them in the car that is parked blocking the entryway to a business. They knock on the door, and the person is having trouble responding, is pawing at the door. Upon the door being opened or the window being opened, the officers smell alcohol. What are again, to get back to Justice Englander's question, where is the unreasonableness in view of those findings of fact?
In those findings of fact, what the judge indicated in his findings of fact was, again, the unreasonable is there was no danger. The smell of alcohol is not indicative of being drunk. The car wasn't on a road.
But isn't the smell of alcohol combined with the fact that she's asleep in a car in the middle of the day, parked funny, enough for them to ask further questions, further investigate whether she might be intoxicated?
And yes, but the record doesn't indicate that they did not ask her whether she was intoxicated. There was no emergency where they can have a warrantless search the way that they did. If they did, they should have said, can we...
Well, the warrantless search was because they decided to arrest her, right?
Correct.
I thought that was going to be your answer to my question.
Okay.
What they shouldn't have done was arrest her.
Well, that's part of it. They shouldn't have arrested her because where's the probable cause? And then they do an inventory, and they find the vodka
Right, but
bottle in the back.
they can't do the inventory unless they arrest her. So I thought that this case was about the reasonableness of the arrest.
It is about the arrest and the impoundment that comes afterwards.
So, but then is the question before us whether they had probable cause to arrest her for operating under the influence when she's asleep in a car that's running?
No, because what I did was I distinguished between the two gamuts of law here. This was just an investigative, not an investigative, this was just a wellness check, okay? There was no need, I believe, for the police to arrest her and for them to search the car. They didn't even ask her if someone could pick up the car. Normally, if you're leaving your car on private property, you have a right, if you're a store owner, to impound the car, to have it towed. Here, they didn't mention that. They didn't question whether she was drinking. They didn't question whether
What
she
should
had
the police
friends.
have done? Should the police, in your view, not have inventoried the car? They should have left the car not running anymore, but parked across two parking spaces, potentially in the way of the business. I mean, we have a finding from the judge, as Judge Neyman points out, that it's in the way. So the police should have left it there?
I believe that the police should have asked my client, do you have someone to pick the car up? It should have been her right to turn off
Are they
the car.
required to do that?
Are they required to do that? There's 4 instances when they're required to do it. Number one, I see what you're getting at. Number one is when you're parked on, a private property, such as a store. But the car posed no danger. There was nothing that was dangerous in it that would just...
Don't we have a finding that it's in the way?
We have a finding, and when
Are you challenging it as?
I'm challenging it because, again, they said the entrance, but the witnesses said the exit, including the pedestrian that came in to pick up her car. There's testimony in there.
Oh, it's clear error?
I say it's clear error.
So how do we get there when Officer Doherty testified that it was at least partially blocking the north side entrance? That's the testimony. Why can't the judge credit that?
I looked at the transcripts. I saw his testimony. He did not remember that day as clear as he should have. The judge took his testimony, put it into the findings. What was both, and they even took, my brother in his brief even mentions, they took an aerial view of the store. You have an entranceway and you have an exit. Now, the pedestrian that came to pick up her car.
How can we tell from the picture which one's the entrance and which one's the exit, or whether they're different?
I can't tell which it is, but I can't read the sign saying enter or exit. But the 2 witnesses that were there testified that it was the exit. That was,
Is it really that much better if she's only blocking the exit?
That's only the police officer's testimony. The others he wasn't blocking anything really. She was parked diagonally in this 2 spots, taking it up. There was really no impediment to traffic that goes in or out. The only thing that impeded it was the ambulance and the police cars. And so what we have here is that she's sleeping in a car. There's no impediment that traffic could come out because it is an exit. What we have here is just person fell asleep in the car. Yes, she had a vodka bottle in the back seat. They claim it was plain view. The officers didn't mention that when they approached the car. There was no stop even, for that matter. The car was stopped. She was sleeping in a car. She could have been sleeping in a mall, waiting for her friend to come out.
I'm sorry to interrupt you, but before you run out of time, I have a question, just a quick one on the impoundment argument. The inventory search. Are you familiar with the case of Commonwealth versus Ferrara, which issued from the SJC on August 26th? It's
No.
SJC 13711. It addresses inventory searches.
I did not.
Okay, thank you.
Do you want to talk about the long argument?
I will talk about the long argument. At trial, they made an argument saying that, again, Walpole is basically a white neighborhood, and that the police officer who arrested her did it because it was racial profiling, and the judge dismissed that. We know that.
But there's a motion for new trial, right?
Yes,
Okay, so it wasn't raised at trial.
correct.
Okay. So the error would have to be a denial. Well, wait, no, I'm sorry. It was a motion for a long hearing.
Yes, there was a motion for a long hearing, and they
That
submit,
came before trial.
yes,
It was
and,
denied.
correct. It
So
was
what's
denied.
the error here?
I believe the error was that the trial judge overlooked all of the data, and that was big data. In fact, the paper takes up about that much of my space here. And you could
Okay,
go
but the data was about stops. Right?
It was about stops.
Yeah, but the problem here isn't the stop. That's why I've been asking the questions I've been asking. Right? I mean, they got a phone call.
And the
Police
judge,
officer was totally appropriately there. Can't claim that the police officer engaged in any kind of profiling or discrimination in appearing at that car. So the data is about stops. So what is the long argument?
well, here we got Commonwealth versus Robinson Van Rada, which I said.
Okay, so it doesn't just apply to stops, it also,
Correct.
it doesn't just apply to traffic stops, it also applies to stops of people
Right.
who are walking.
Correct.
Or on bicycles, I
Right,
think, in that case.
pedestrians,
All right,
correct.
but that's not this case either. This case is this case about the arrest?
It is about the arrest.
Okay. Is there any data about the officer's arrest?
Yes, and there's a whole bunch of data saying, I can't do all the percentages off the top of my mind, but her report concluded that the distinguishable data saw that white motorists were giving less citations, less arrests than those of black motorists or Hispanic motorists.
I didn't
69.9% of white motorists cited were issued warnings and civil citations to 20% and criminal citations to 5%. And with regard to black motorists, warnings to 64.2%, civil citations to 20.8%, and criminal citations to 5.7%.
That's the 8 years that the judge, examined. But there has been also data going back from 2014 to 2019, when she was stopped. She issued larger percentages of citations to black and Hispanic motorists than the percentages of black and Hispanic motorists driving in Walpole. This disparity between the proportions of black and Hispanic...
Start again. What was the disparity in?
Giving citations to black and Hispanic motorists than the percentages of black and Hispanic motorists
Giving
driving in
citations as opposed to warnings.
Walpole. Correct.
Is that data relevant to the arrest, to an argument about arrest?
I think it would be. I think it would be. I think in this case,
How?
the fact that the totality of the circumstances of a black woman being in a car, we never found out if she was inebriated because she couldn't take the breathalyzer. She was overcome with sadness and crying. The other factors as well, that the car wasn't moving, there was no danger, leads me to believe that the arrest was unconstitutional and violated her rights.
You're over a minute past your allotted time, but let me see if my colleagues have further questions.
Just one more. You're not an employee of CPCS, are you?
I am.
You are an employee.
I am.
You work for CPCS?
I work for CPCS.
I thought you worked for the Bentley Law Group.
I am also with the Bentley Law Group, but I am with CPCS, yes.
You're a bar advocate or you're an employee?
Excuse me?
You're a bar advocate or you're an employee?
I'm a bar advocate. I'm a private attorney.
Yeah, so you don't write CPCS on your brief if you're not an employee of CPCS. Okay?
Okay. All right, thanks a lot.
Thank you very much.
All right,
We
take
appreciate your argument. We'll now hear from the Commonwealth.
Morning, Your Honors. May it please the Court, Caleb Schillinger for the Commonwealth. Back up to the impoundment issue. I had understood the claim to be focused on the reasonableness of the decision to impound the vehicle, which is why I focused that on the brief, and apologize if I did a disservice to the Court by focusing on that as opposed to the entire progression leading up to it. But to try and cover that very briefly, I heard my brother say, what did the defendant do that was wrong that would justify this? And I would just emphasize that, again, this started out as a community caretaking function. The police received a report of an unconscious occupant in a motor vehicle slumped over the wheel. It was appropriate for them to respond and to check on that occupant to determine whether she was in need of emergency medical assistance or to determine what the circumstances were that found her parked across multiple parking spaces, partially blocking the entrance and slumped unconscious over the steering wheel. To the extent that the defendant is challenging the judge's factual finding that the vehicle was partially blocking the entrance, it was amply supported by the evidence that was adduced at the suppression hearing. Officer Doherty testified that the vehicle was at least partially blocking the north side entrance. It was in the parking lot, not in a spot partially blocking the entrance, and there was nobody to take possession of it. This is on pages 6 through 7 and 12 of the suppression hearing transcript, and then testified to that effect again later on pages 35 through 36. So there was ample evidence which the judge credited to support the factual finding that this vehicle was not lawfully parked. It was straddled across multiple parking spots and was partially blocking the
Are you
entrance.
familiar with the Ferrara case which just issued from the SJC?
I am, Your Honor, yes.
Does that impact your argument in any way?
The only aspect I would say it impacts is it perhaps undercuts the assertion I made in my brief that even if there were a violation of the policy here, that would not be a basis for suppression, because it goes to how my argument was that there needs to be a violation of the policy as to how the inventory search is conducted, as opposed to the decision to impound the vehicle in the first instance. I think courts have dealt with that more broadly, and I think the language in Ferrara would suggest that to the extent there was a violation of the policy here, even as it relates to the decision to impound the vehicle, that would be relevant. I would suggest, however, that there was no violation of the policy here.
Would be relevant because it would show that it was, because one could make an argument that it was unreasonable to impound the vehicle even if objectively it was reasonable, if it violated the policy of the I'm trying to figure out how it's relevant.
It would be
it's relevant because the policy is itself indicative of what is reasonable, I guess.
It would be relevant as to the second prong of the analysis, which is that the officers have conducted the impoundment and inventory in conformance with the standard written policy. Not relevant, Your Honor, as to the first prong, which is the reasonableness of the decision to impound the vehicle. And again, I would suggest here that the decision to impound the vehicle was reasonable under all of the circumstances, given the positioning of the vehicle, that there was no one else to take possession of the vehicle. The sole occupant was the driver who'd been arrested for operating under the influence. Unless Your Honors have any questions as to the arrest, the impoundment.
I have a question on the long motion.
Yes.
Why was the judge correct in ruling that the defendant did not sustain her burden under the long protocol, let's call it? I mean, it seems that there was statistical evidence presented. I understand the judge found that statistical evidence to be statistically meaningless, but is the judge in position to do that? Shouldn't the judge have accepted that and moved on to the second prong, which is to establish race-neutral reasons for the officer's conduct?
No, I think it's fair for the judge to consider, as part of determining whether the defendant has satisfied her initial burden, to look at the material that she has submitted in support of, carrying that burden, which was the statistical information. And again, this wasn't the judge's analysis and computation of the figures.
But the judge is reviewing the same analysis as the expert. The expert, I believe, averred that this is statistically significant, and the judge said, no, it's not.
I think the judge is within his right to find that unpersuasive, where it's sort of conclusory. If you look at the report the portion that was submitted as part of the appendix, the expert simply opines or asserts.
Parts of it are conclusory.
I'm sorry?
Parts of it are conclusory. Other parts of it I have questions about because they have data in them that might support a view that there was unequal treatment. Let's go back. The first thing the judge said, as I read his decision, is he doesn't think the long protocol applies to this situation because it's not a traffic stop situation, right?
He assumes without deciding that it would apply here, even though there was no stop in this case. So he does look to the long factors. He doesn't simply dismiss long and the
Well, I
non-exclusive
thought he
list of
said it
factors out
doesn't
of hand.
apply, but maybe I misread it. He assumes without deciding? Hold on, let me just make sure that I'm on the same page with you on that.
Sorry, Your Honor. It is on page 43 of my brief, or the addendum. This is the first page of the judge's decision on the long motion, and the last word, starting with the last word of the penultimate sentence on that page, assuming without deciding that the test established by long applies in this case, where no stop took place, the defendant bears the burden of establishing that initial inference of racial profiling, and then goes on to say that, looking to those factors, admittedly, there's not an in-depth analysis of them, but credit the judge's statement that, he considered those factors, finds that they either don't apply, given the unique circumstances here, or cut against the defendant. So
Okay.
I don't think
Sorry. Yeah, he does say that. Because the Equal Protection Clause applies, right? Even if the problem is with an arrest.
It does. I wouldn't suggest that because this is a community caretaking function and coming upon a vehicle that's already at rest, there can't be such a claim raised, or that long Robinson.
So how
apply.
would it be the same? I mean, there's a discussion in Long about how with traffic stops, you can assume that everybody's violating the law. And so you're, in your comparators, if you will, those people who could be stopped versus those who are stopped, they just say, well, everybody on the road could be stopped because for purposes of a traffic violation, and any of them could be stopped. That's sort of like they get over that hump. But when we're talking about arrest, it's not the same, right? I mean, we can't assume that the universe of people who could have been arrested was every single person who was in the town of Walpole at that time. So would the test be different? Would we have to think about it differently? Do you follow what I'm saying?
To be perfectly candid, not entirely, Your Honor,
Okay.
but I will try and tackle it as best I can. And I think what I have
I don't
found-
blame you for saying that, but as I was reading this last night, this is what I was thinking, is that, Judge Gaziano goes through this sort of, well, how would we decide if someone's being discriminated against? Well, it would be all the people who could be, who legitimately could be stopped versus all the people who were. And then we'll look at the ones who were and we'll ask the question, does the racial profile of those people not match the racial profile of the people who could be stopped? And he gets over that hump by saying, well, we can figure out who could be stopped because everybody's violating the traffic laws, basically. You see what I'm saying?
I
Not
do.
true of arrest, right?
Right. And so fair point. And I think, that sort of statistical analysis or evaluation is one factor. It's one aspect of it. But again, it's the totality of the circumstances. And I think it goes too far to suggest under existing precedent that there could never be a long claim in the context of where police are performing community caretaking function. You could imagine a hypothetical where they respond to an emergency, something happens to suggest it then elevates to an investigatory aspect.
I agree with you.
Motivated by racial prejudice.
And as I was thinking about this problem, because the question is there enough before this judge so the judge should have had an evidentiary hearing? That's the question, right?
And I think that the judge was correct in finding that there wasn't, because there's nothing in here to support the notion that the police at some point exercised their discretion to target this individual for further investigation or enforcement by virtue of the fact that she is black.
Of her race.
They're there on a community caretaking function. They didn't choose this individual. They are doing their duty. They're responding as they were directed to do. And when they get there, there's no evidence that somehow the encounter, becomes investigatory because of, who
Okay.
this defendant
And
is.
If I can interrupt.
Of course.
I accept that. I think that's what the SJC did in the Robinson case, in the case about the stop of the two boys on the bicycle that succeeds long. But if the question is there enough there so that the judge should have had a hearing about whether the arrest was based on was motivated by race, which is the legal question. What about Table 7, which we were just pointed to?
I think
Table 7, the race and ethnicity of motorists cited by the officer by post-stop outcome, which I had not focused on this until a moment ago. So I'm really asking the question, what does Table 7 tell us? It looks to me like out of 488 white people who were stopped, 5% were arrested. Out of 53 blacks, 10% were arrested. Is there anything that we should be taking from that? Am I misreading it? Am I misunderstanding it? Because honestly, you're right. It's a pretty conclusory sort of set of conclusions am I misunderstanding this?
I don't know, Your Honor. I don't have it right in front of me. But what I'd suggest is just in the abstract by itself, I think it is sort of focusing in isolation on that as opposed to, or to frame it differently, I think it's appropriate for the judge to look more broadly at this officer's or the data relating to this officer's encounters post-stop. So warnings, citations, arrests, and not to focus solely on the aspect of the arrests. And again, the data that
it's rather strange that the judge cherry picks out warning, civil citations, and criminal citations, because those numbers are pretty similar, and just ignores the search and arrest numbers, which are really different. I mean, how do we bless that?
I don't recall that they were that different, Your Honor. I'm sorry. I thought that the three numbers were actually pretty similar, and I thought just
The warning, civil citation, and criminal citation numbers are pretty similar, but then searches, 0% of the white motorists, as opposed to 2% of the black motorists, and arrests, 4.9% of the white motorists versus 9.4% of the black motorists. And the judge just kind of ignores those numbers. I mean,
Yeah,
There weren't
is there a reason
many
why we should do
searches.
that too? I mean, is there a reason to ignore those numbers? I mean, really, is there a reason why the warning, civil citation, criminal citation numbers are more significant here than the arrest numbers?
I don't think so, Your Honor, and I don't know, because the opinion doesn't indicate why, the judge cited some of those numbers but not the others. But again, I would fall back to, it is a component, it is a factor to be considered, but looking at the totality of the circumstances here, the officer did exactly what we would expect officers in this position to do. He has an encounter with the defendant pursuant to a community caretaking function. And once he starts to have that interaction, he detects indicia of intoxication, slurred speech, glassy eyes, the odor of alcohol. We would expect an officer in that situation to follow up and investigate whether or not this individual may be impaired and has been operating under the influence.
But isn't that something you'd establish at the long hearing? We get to a long hearing, and then the officer explains why he did what he did, and the judge says, okay, I believe it was not racial, and then you win, right?
If you had not already had an evidentiary hearing, yes, but the judge here had the benefit of the prior evidentiary hearing in the record that was established as part of that, which the defendant...
Was it the same judge?
Same judge. The defendant also relied upon that prior evidentiary hearing and information to support her motion. The judge incorporated his findings...
Oh, that's helpful. Okay, so somewhere in here he says he incorporates his findings into the decision on Long?
He does, Your Honor, yes. There's a statement, and I could find the exact page.
No, that's all right. We can read it, but thank you.
Yes, so he wasn't doing this in a vacuum. This was the exact same judge who had heard the Article 14 motion to suppress, incorporated by reference, that evidentiary hearing and his findings on that from before as well.
The judges
Yeah.
makes mention of the prior proceedings at Record Appendix 27, so we have it.
But I didn't really internalize that until you mentioned it.
I'm sorry?
I didn't highlight that until you mentioned it, that.
Yes, and suggested, yes, that's significant. This judge was aware of the circumstance there. Unless there's anything else, I'll rest on the remaining arguments on my brief, and if I may break protocol just for a moment to say, Justice Englander, thank you for your service to the Commonwealth. I had the pleasure of appearing in front of you a number of times at oral argument. It's a privilege to be here today on your last sitting, and I have been the subject of intense questioning by you before. Rapid fire questioning, in fact, and I can
Which your mother-in-law has complained to me about.
You have, for what it is worth, from someone who stands up here at the podium, you have pushed us to, prepare, to ask why, and to try and seek a just outcome. Thank you.
Thank you. Well argued by both counsel. The case is submitted. Thank you both. Calling our second case on the list, docket 24P989, Commonwealth v. Maney. We'll hear first from Attorney Peterson. Good morning. Good to see you.
Good morning, and may it please the court. So there are two issues that are highlighted in my brief. I'm going to start with the ineffective assistance and the motion for new trial. I would start out by saying that I think it's important to remind ourselves of the standard, which I know the court is well aware of, that the evidence presented to get an evidentiary hearing does not have to be conclusive. It does not have to, I do not have to prove that it would have changed the jury's verdict. It has to show that it's a substantial issue. I had cited some cases that are important to this. Gordon says that an evidentiary hearing is required to address ambiguities and gaps in the evidence, and that Smith says judges shouldn't be too quick in denying these hearings. And Goudreau says the evidence only has to cast doubt and not to prove the case.
I hate to interrupt. I have a preliminary question. At page 12 of your brief, you state that we look to see whether there's error and then analyzes whether it's harmless beyond a reasonable doubt. Where there was no objection, need the Commonwealth prove harmlessness beyond a reasonable doubt, or do we just apply the SRMJ factors, none of which is harmless beyond a reasonable doubt proof?
Yes, so I believe that is correct, that there wasn't that is the standard that I was relying upon for the issue of the comment that the prosecutor made. So I do believe it is a substantial risk of miscarriage of justice.
Right, so we look at what are called the ALPHAS factors, right? The strength of the Commonwealth's case, the nature of the error, whether the error is sufficiently significant in the context of trial to make plausible an inference the jury's result might have been otherwise but for the error, etc. We don't look to see whether it's harmless beyond a reasonable doubt, correct?
I believe that would be the standard if there was an objection, but I believe that there's a substantial risk of a miscarriage of justice, and I apologize if I misstated that standard in my brief that related to the issue of the prosecutor's comment.
I'm sorry for interrupting you. Go ahead.
Oh, no problem at all. So, and it's important to note that in the context of the ineffective assistance, we don't look at this in the light most favorable to the Commonwealth in deciding whether to do an evidentiary hearing. I believe that the lower court judge kind of did some of that where he looked at, well, they've got all of this evidence, and if you look at all this evidence in their case, this evidence may not have helped you as much as you want it to have, and that is certainly not the standard. There are multiple factual gaps and multiple issues that should have necessitated an evidentiary hearing here with Dr. Rosenbaum's affidavit. First, trial counsel admitted that this evidence would have been helpful if he would have presented it. This is Counsel Gillespie in his affidavit. And also that Mr. Maney in his affidavit and the two other...
What does he say exactly? He says this would have been helpful?
Yes. This would have been helpful to present.
So you take that affidavit after the fact as rebutting a point which is made by the Commonwealth, which is, hey, this could have been a tactical decision on their part not to pursue this, right? Commonwealth says this could have been tactical, and I want to explore that a little bit. But does this sort of one-off statement by trial counsel, this would have been helpful, that rebuts that?
I do believe it does, and I do believe that standard is not also whether it, a tactical decision has to be reasonable, it has to be based on proper investigation. And I think part of the issue here is that trial counsel had no idea that this evidence was even out there because they did not pursue it, despite Mr.
Well, you say this evidence. I'm interested in what you think this evidence is.
Sure, so it's Dr. Rosenbaum's affidavit.
No, I read it.
So Dr. Rosenbaum's affidavit that essentially these medical conditions could have caused...
These medical conditions could have...
Yes.
Could be the explanation, could have caused.
Could have caused him to appear impaired or under the influence without him being under the influence, which I think is crucial.
If that is even sufficient to survive a Lanigan challenge. Let's assume it is. Let's assume that's an opinion. Could have is an opinion that's relevant. Isn't he going to be cross-examined on a couple of pretty important questions?
Sure, and that...
Let's start with this one. Did you review the entire medical history of the defendant? Did the defendant have an alcoholism problem? Would that question be a legitimate question to ask of an expert?
I believe that could have been litigated in a motion in limine, and I believe that I don't believe that there's any record of Mr. Maney having an alcoholism issue or that being present in his medical records. I don't believe there's any record of that in the record before this court.
I mean, this is an extraordinary, to me, this is extraordinary because I'm not used to seeing an expert who says, based on what I've seen in the medical records, this could have been the reason. And we should reopen the trial. He gets a new trial because this is what I think. You put an expert on the stand, he has to have looked at all his medical records, doesn't he?
He certainly would have. And
okay, is there anything in here that indicates that he saw all of his medical records?
I believe that his affidavit says he reviewed the records.
When you say there's nothing in the record that indicates that your client has an alcoholism problem, this was his third OUI.
Correct, which is
okay.
An issue that would not have come before the jury.
Oh, but it might have.
And
tell me you'd be able to exclude from a cross-examination of this expert whether or not he reviewed the entire medical record and medical history of the defendant.
I mean, I believe that's propensity evidence that there would have been a good argument to exclude that.
Well, no, because he's giving an opinion. This is what, and it's not, I know it's not an opinion that says, this is what I think happened on that day, which would be relevant. But if he gives the opinion, this is what I think happened on that day, he doesn't mention at all the smell of alcohol, the open container of alcohol. He doesn't mention that in his, isn't he going to be crossed on all that? How could that possibly be excluded from cross-examination?
Well, I think we're two levels of hypotheticals down here when the issue is just that is there a substantial issue presented here, but certainly he would have been cross-examined on that, and if it existed that there was a documented alcohol problem in Mr. Maney's medical records, that would have been subject to a motion in limine, and it could have come in. And the
problem I have, and I think that's a fair answer, counsel, I think that's a fair answer. The problem I have is we are sort of two levels of hypothetical down, but none of that, so you would say this is why we needed to have an evidentiary hearing.
Correct. To determine.
What's in my head is, boy, and maybe the judge's head too, boy, I don't think that this ever was going to fly. And there's not enough in the record to suggest to me that I should spend my time having an evidentiary hearing on this because there are huge problems with putting this expert anywhere near a witness stand.
And I think that this evidence is regularly used in courts. I mean, there are plenty of reported cases about the use of experts to explain diabetes and how it could affect someone's presentation in an OUI, and a lot of these sort of things. But I think that this is the exact sort of factual issue that causes us to need an evidentiary hearing.
So it's not uncommon to have someone take the stand in an OUI case. Remember, we got this judge for 25 years who says he's never seen it, never ever seen it.
And
Okay, but you're telling me this happens, and I understand that and believe it. When it happens, isn't his entire medical record subject to examination?
potentially, I mean, I think that would be subject to a motion in limine. And I would, if I was his trial counsel, I certainly would have tried to exclude that evidence as propensity.
Of course you would, yeah.
And I think that that's a further question. But I think the issue here is that the jury was presented with a very incomplete picture of what the symptoms were and what his presentation.
So this is what I don't get. I can see why you need an expert to tell you what people with diabetes, how they act. And there is an expert, what's plainly expert opinion in Dr. Rosenbaum, where he said he suffers from central sleep apnea. Now, a layperson can't figure that out. But beyond that, we have that his abnormal speech and confusion would have been reasonably explained by his having been aroused from a deep sleep state. Why is that an expert opinion? Why can't a layperson figure out that if someone's in a deep sleep state, they can have abnormal speech and confusion?
Well, because I think that the evidence before the jury, and I pointed this out to the judge in the motion for new trial hearing, was Officer Murphy saying, well, when I'm woken up from a deep sleep, I'm very awake and active and alert, which is, and the Commonwealth kind of seized on that to say, yes, we don't know how it affects people, but we do have a good idea of how it affected Mr. Maney that wasn't explored by trial counsel. And even if trial counsel would have eventually decided, hey, this isn't something we want to present, there are too many risks, they didn't do the investigation.
I get why it's useful. What I don't get is why it's expert.
I don't believe, and certainly I read Dr. Rosenbaum's affidavit, and I didn't go to medical school. I did not know that before reading the affidavit, and maybe I'm less knowledgeable than the average juror.
People in a deep sleep state have abnormal speech and confusion when woken up?
I'm sorry?
You didn't know that people in a deep sleep state, when woken up, had abnormal speach and confusion? Because I didn't go to medical school, but I knew that.
I think that's one potential.
My wife definitely taught me that.
And I think that that's one thing, but the other issues are the other medical problems that could have led to his prolonged state. Because if you read the motion for new trial transcript, the judge there says, well, sleep apnea stops when you wake up, or things like that would have been contradicted by Dr. Rosenbaum's affidavit and Dr. Rosenbaum's opinion here.
I mean, sleep apnea does stop when you wake up, but it still makes you tired. Right?
Correct, and it still has effects on you after you wake up, but the judge's opinion and the evidence that the Commonwealth was relied upon at the trial is actually contradicted by this, and I think that certainly if you imagine a lay person getting up there and saying, like imagine if they asked his girlfriend, what about sleep apnea? How does that affect the nervous system? What about sleep deprivation? How does that affect somebody? That would have been an objection. That would have been a sustained objection because that's an expert testimony.
But you could ask her, how does he react when wakened from a deep sleep, which she was asked, right?
She was asked that, but I believe that the jury was presented with a very incomplete picture of how his medical situation could have led to it because the trial counsel didn't investigate it whatsoever.
Speaking of what was presented to the jury, was the body-worn police camera footage presented to the jury?
It was. So it was,
and also it was considered by the expert.
It
and
was.
Also it's relevant to us in terms of the denial of the motion for new trial, because we're supposed to look at what is averred in the affidavits. Plus, it's relevant to the issue of the strength of the evidence at trial in analyzing the closing argument issue. And I don't think we were provided that footage by either party.
So I talked to my sister about that, and we we are going to provide that if the court wants it, and we certainly can. That is something that we noticed and we talked about last week.
So we will not issue an order. We will rely upon both of you to provide that to the court within the next week.
Yes.
If you don't provide it, then we will issue an order.
Sure, we will certainly do that.
Thank you.
In my remaining time, I do want to address
Yeah, can we, let's
the
let's
closing
talk
argument
about it.
issue. And I think that this is, the legislature in Section 23 makes this clear that prosecutors shouldn't refer to it or comment.
Well, no, 23 says you can't talk about the defendant, the fact that the defendant did not testify at any preliminary hearing in the first court.
And I
Was
believe
there a
this.
preliminary hearing that the prosecutor was referring to?
So if you read further on in that section, I believe, and
Or
it's,
that at such hearing, he waived examination or did not offer evidence in his own defense.
and so I read that as talking about the current hearing. Not testified, that at such hearing he waived examination, didn't offer evidence in his defense. The such hearing, I mean, certainly there's a principle here that goes beyond what the statute says.
Well, okay, but don't pivot so quickly, because your point in your briefs is there's a statute that says specifically you can't comment. What's the exact language? I'm sorry. The fact that the defendant did not testify shall not be referred to. And you said, hey, Commonwealth doesn't even deal with that. And,
Correct.
And I think you would say the statements by the prosecutor referred to the fact that the defendant did not testify?
Correct. So
Did they?
they said the defendant has a right not to testify.
That's a little different.
And I think that.
That's a lot different. That's a correct statement of law.
But I think.
Your time has expired, but please answer Justice Englander's question. We
I
may
might
have
a
further
couple more,
questions for you.
yeah.
And I think that there's a big difference here with, the court here has to look at this in a cold record. And you think of the creative ways that prosecutors could use to refer to this. Now, don't think about the fact he didn't testify. Don't do it. Don't think of a white bear, like Justice Stevens said. But then.
In dissent.
In dissent, sure. But I think the
Dissent.
principle still applies, is that.
No, it's not even a principle. It's a dissenter's view.
Right, I think the analogy still applies, then I may have used it wrong.
I understand the point, but it was interesting to me that some of the strongest argument you made was out of a Supreme Court dissent.
Correct, and I think that, so I wouldn't say it's the strongest argument, I would say it's a good analogy to what we're dealing with here, where a prosecutor could use creative language to refer to this if this court does not step in here and argue these points.
Here's what the prosecutor said. The defendant has and you'll hear this from the judge, so he's tying it to, has an absolute right not to testify. He doesn't have to put on a case. He doesn't have to present any evidence. Now, that statement is a correct statement of law.
Correct, but
Okay, now, is that a comment or a reference to the fact that the defendant did not testify, which is the statutory language that you've referred us to?
I think that it's a reference, certainly. And I think that if you look at the way this was done and the way that it could be abused and the way that there's a reason why the court up until recently said that the defendant's the one that has to request the instruction on the right not to testify, because it's such a sensitive issue that you don't even want to put it in a jury's mind.
Right,
And-
but he did in this case.
Yeah, so where's the prejudice where he did request the instruction was given, and the prosecutor is arguably merely just repeating the judge's instruction, which prosecutors may do as a general rule?
Sure. So I think the issue is the difference between it coming from the judge and coming from the prosecutor. There's a reason why the statute says the prosecutor shouldn't refer to it and not the judge shouldn't refer to it. Because the jury, when they listen to a prosecutor's closing argument, assumes that they're advocating for their point. They're assuming that they're taking this in a certain way. This is the prosecutor's point of view. Whereas when the judge says something and that instruction is very strong, it's taken from a different point of view than when the prosecutor says it. So I think that that's the prejudice here, is you have a prosecutor, especially when they contrast it with the defendant's evidence they did put on, and say essentially this could be scrutinized, but you couldn't scrutinize what he said because he didn't talk to you. And unless there are any
I
further.
suppose there's a difference, it depends on the tone, right? Like, there's a big distinction between someone saying, for example, you know, as the judge is going to instruct you, he need not testify, versus, hey, he need not testify.
And I think that's the exact issue, is that this court can't see winks on, and obviously we're on YouTube here, but if there's a transcript of this, they couldn't see the difference
But
between
there's
your
no
two
evidence of
statements.
that either.
Right, and there's no evidence that
Yeah, that argument doesn't help you. That argument walks directly into the point that there was no objection at trial, and that's an indication perhaps that nobody thought that much of it at trial.
or it could be an indication of a potential ineffective assistance, which is the same standard that we're in front of here with the substantial risk of miscarriage of justice.
Do you have a final question? Okay.
Thank you.
Excellent argument. Thank you very much.
Thank you.
Commonwealth.
Good morning. May it please the court, Emily Jamalowitz for the Commonwealth. I guess I can just start maybe with the closing argument issue.
Yeah, why don't we start with the statute? So Justice Ditkoff asked the question whether the statute even applies. But if it does apply, so you should address that. But then if it does apply, you didn't respond to it in your brief. I mean, was the statute violated here by the prosecutor?
I don't think so. The statute refers to commenting on the defendant's failure to testify. And my position is this was not a comment on his failure to testify. So I'm not really sure that the statute really matters all that much.
The word comment is not in the statute. The word referred to is in the statute. This is not a reference to
Right. I
the
don't
fact
think
that he
it's,
did not testify?
No, I think it's a statement of law, is an accurate statement of law, referring to the fact that the defendant doesn't have a burden here. I think that's certainly a legitimate point that she was making. I'm just not sure that this is what this statute is really getting at. And the other point I would make about the statute is that it doesn't...
Well, let's start with the statutory language. Is it a reference to the fact that the defendant didn't testify? It seems, I mean, your brother says, yeah, it is, and it seems like it is to me. Yeah. Wait, hold on, let's just be clear. He doesn't have to testify.
He has an absolute right not to testify. What else are they referring to?
I think the point...
Just doing a great job of repeating the judge's instructions and asserting the rights on behalf of the defendant? Is that what the prosecutor's doing?
I think she's trying to be very careful and caveat her language by repeating what the defendant's burden is, or the defendant's lack of burden.
I think if a prosecutor were being careful, they wouldn't go anywhere near referencing defendant not testifying or having a right not to testify. I mean, would you agree it's generally, as a general rule, it's a bad idea for a prosecutor to say anything about defendant's right not to testify, particularly where the defendant exercised that constitutional right?
Sure.
Bad choice, right?
I agree that perhaps the language could have been more carefully chosen. But I do...
Why go there at all, though?
Well,
why not just say, hey, she testified, here's why she's not credible. Why get into the defendant not testifying? I'm not seeing the upside of that on behalf of the prosecution. I am seeing a downside.
I just think that where she says that in the context of also then saying, he doesn't have to testify, he has no burden, I have the only burden here, I think she was trying to cover all her bases and essentially offer a disclaimer to the jury. I really want you to understand, jury, that what I'm about to say is in no way a statement that this defendant has some kind of burden to produce more, better evidence.
That she thought she needed to do that because she was going to attack the only evidence that the defendant did put on?
Yes. I think she was preparing to pretty aggressively criticize the only evidence that the defendant had, and I think it was said out of an abundance of caution in an attempt to ensure that her subsequent comments were not mistaken as a...
This is a district court trial, right?
It is.
Defendant have to provide who the witnesses are going to be before trial?
Yes.
They do. Okay, she knew that the girlfriend was going to testify.
I believe so, yes.
Or she prepared her closing. In other words, she didn't just get surprised by it a few moments before.
I don't believe so.
Okay.
So am I wrong? Do we ignore at any preliminary hearing in the first court? This
No.
looked like a statute about trial de novo.
I guess I think that's my point. I'm not really sure that this statute is especially relevant to this particular situation. The case law that examines the issue of prosecutors' closing arguments, none of those cases refer to this statute. They really refer to sort of looking at the statement, a prosecutor can't use this
I mean, the mere fact that
silence.
the statute doesn't prohibit it doesn't make it okay.
No, of course.
Why would, so, as a burning example of my lack of knowledge compared to the other two to my right, why would this statute exclude, why would it be appropriate to read the statute as not applying to this trial? As opposed to some preliminary hearing or something else? I mean, I read the language, it is a little awkward, but I just assumed it would apply to any trial in the Commonwealth.
I think, I'm not necessarily saying the statute doesn't apply to trials in general, but the statute is talking about using testimony from like a prior hearing, and that you can't use failure to testify at that prior hearing at the actual trial itself.
Maybe it's an artifact of the old de novo review. You get two trials in the district court, one before
I think
a judge
that might,
and
I think
before a
that's
jury.
right.
Are there any published cases from our court or the SJC addressing when and how 278.3 applies?
I couldn't find any. I certainly couldn't find any that dealt with that statute in the context of a prosecutor's closing argument. Because if there's nothing else on the closing argument, I can move on to the ineffective assistance.
Please.
Okay. So my position is that trial counsel's performance here was reasonable and strategic. I think it was a valid strategic decision to decline to consult with this expert, to call this expert. Certainly the
Well, we don't know if it
affidavits-
was a strategic decision, because the only thing we have is an affidavit that says that would have been helpful.
Well, I think being helpful is not the standard. There are a lot of things that would have been helpful.
Right, but it also doesn't indicate it was, the trial counsel didn't say, I'm not going to give you that affidavit, or, no, I made a strategic decision not to pursue this because I thought the guy would get skewered if I ever put him on the stand. He didn't say either one of those things. He said, yeah, I thought it would be helpful. Yeah, if he'd given me that, it would have been helpful.
No, but they do say, I believe both of them say, that they had discussions with the defendant about retaining a, quote, sleep expert, and ultimately advised against it because they believed that this type of testimony was within the experience of a juror. That, I think, is essentially the reasonable basis that the affidavits present to the judge. And I think that's a reasonable sort of tactical decision.
Is there a problem that both trial counsel averred that the defendant, or at least they didn't recall the defendant telling them that he had asthma or sleep apnea? Or is the burden on them to ask their client such things?
I mean, I think they both aver that they had extensive discussions with him about retaining a sleep expert. I think I'm a little bit skeptical that in those extensive conversations that this wasn't a topic that would have come up. I'm not sure that there's really anything in the record that suggests that the defendant really was suffering from these kind of medical conditions at the time. The doctor's affidavit, I think, kind of hedges on whether he had sleep apnea at the time, whether he has it now. So it's not entirely clear to me that there was anything for them to find.
Does Dr. Rosenbaum aver in his affidavit that he is a sleep expert? He says he's an ER doctor. He says he's experienced and trained in the area of issues of alcohol, how alcohol affects people. Does he actually aver that he is a sleep expert of any kind?
No, I believe he says that he's an emergency room doctor who's encountered people suffering from various sleep conditions in the course of that, but he doesn't actually identify himself as a sleep expert.
based on what's in here, would it survive, I mean, is it relevant? Would it survive a challenge under Lanigan?
I guess I'm not sure that it would. I mean, the doctor, I'm not really sure ultimately. I'm not even really entirely sure. The opinion he theoretically would be offering was the defendant was groggy and disoriented because he, I guess, was sleep deprived due to his sleep apnea, or that his various medical conditions would result in this.
I mean, there are a lot of things here that aren't specific to the defendant. Could have explained, could explain. But there is this statement on paragraph 5, Mr. Maney's documented medical history of sleep apnea, asthma, and sleep deprivation would have combined to impair his level of alertness and consciousness. Would have combined. That sounds like maybe it's an opinion about this case.
I mean, I guess I'm just not entirely sure that this would have been admissible in the form that it's presented. I mean, ultimately, an expert is offered to, essentially offer an opinion on something that's outside the experience of the life experience of a juror. And on some level, whether somebody is sleep deprived because they have been plowing for 18 hours or because they are not sleeping due to these various medical conditions, the ultimate question for the jury is it because he is exhausted or is it because he is under the influence of alcohol? That I'm not really sure.
I mean, or some other reason. And your brother says, and we're entitled to put in evidence that it could be another reason related to his medical conditions that would not be necessarily within the knowledge of a lay person. So if you've got a sleep expert and they say, hey, sleep apnea could have caused exactly what this guy did, why isn't that a valid, yeah, maybe it's not necessary, but why isn't that a valid expert opinion? It's beyond the knowledge of a lay person, isn't it?
I mean, it may be. I'm just not sure that what's presented here is specific enough to this case that it would really ultimately be admissible. It very well may be, but I think at least what's presented here, it's not. It's perhaps not.
What about my questions to your brother? I mean, I see this. His documented medical history would have combined to impair, and I think, oh, I would love to have this guy on the stand. Did you consider the fact that there was an open can of alcohol and that he smelled like alcohol? I mean, aren't all those, I mean, in fact, isn't everything fair game once he starts talking like that? Am I missing something?
No, I think.
By everything, I mean his history with alcohol.
Well, I think that kind of goes to why retaining the expert or declining to retain the expert is a reasonable strategic decision here. I think counsel would have been aware of the potentially significant pitfalls of putting this expert up. And that gets to whether it was reasonable for them to do that.
Are there other cases that you're familiar with? Your brother says there are other cases where they'll put on experts who, like a diabetes expert or someone who explains the conduct of a defendant in an OUI case based on their medical history. When those happen, are you familiar with any?
I mean, I'm not familiar with any that specifically deal with this sleep issue. I'm certainly aware that experts will testify to things like diabetes or things about the breathalyzer, but I'm not aware of any.
Let's take diabetes. When that happens, does that open up the entire medical history of the defendant?
I mean, certainly the expert is going to have to consider the entire medical history if he's going to come to an opinion. Okay. To the extent that it's admissible or not may depend on the particular circumstances of the case, but I do think it will at least be before the expert.
Right. Okay.
I guess if there's nothing further.
Nope, seeing no further questions, thank you. Both parties very well represented, and the case is submitted.
Thank you.
And thank you for conferring beforehand. That's really helpful to the court.
Calling our next case, docket 24P1128, Commonwealth v. Howard.
Good morning, Your Honors. May it please the Court. My name is Robert D'Auria, and I represent the defendant appellant, David Howard. Your Honors, this appeal is from the conviction of Mr. Howard in the Lawrence District Court of the crime of assault by means of a dangerous weapon. I'd like to take the issues that I raised in my brief somewhat out of the order that they're set forth in the brief. And I'd like to start with the Court's ruling denying the defendant's motion to dismiss. As Your Honors are probably well aware, these motions are decided within the four corners of the police report. And in summary, according to the police report, a gentleman showed up to Mr. Howard's home dressed in jeans and a sweatshirt, wearing no outer sign that he was a constable. He knocked on the door. Mr. Howard initially didn't answer. The constable turned to go back to his car to write a note and came back with the paperwork that he was serving of Mr. Howard. He threw the paperwork down at Mr. Howard's feet, and Mr. Howard tossed the paperwork back, signifying he wasn't accepting service. As the constable did that, he said, "You've been served." Constable then turned to go back to his car, and according to the constable, Mr. Howard is yelling. There's no evidence in the report as to what Mr. Howard was yelling. As the constable turns, he sees Mr. Howard standing in the doorway to his home, holding what the constable then described as a shotgun, I believe a brown stock, black-barreled, long gun. He then called 911. Police arrived. They talked to Mr. Howard. Mr. Howard refused to answer questions as to whether he had a firearm. And the officer who wrote the report concluded that any reasonable person under those circumstances would have realized that this was a constable, inferring that Mr. Howard had no right to possess a firearm, not pointed at anybody, with no evidence that he threatened to shoot. And under those circumstances, the complaint issued over and I provided a copy of my filing in the district court. The issue that in my experience, makes this case somewhat unique is we have this intersection of the Second Amendment and the recent case law, Bruin, Guardado, Rahimi from the Supreme Court more recently. And I had argued to the district court that this interaction had to be viewed through the lens of the Second Amendment. I can't imagine that the Commonwealth would dispute, and certainly our SJC doesn't dispute that Bruin is good law. Starting with Heller, going to McDonald, finally to Bruin, it's very clear, not only do citizens have a right to...
Where does that lead you, okay?
Sure.
Does it lead you to the position that your client had a constitutional right to threaten the man in his driveway with a gun?
Absolutely not, Judge.
Okay, well, that's interesting, okay? We'll take that concession for now, okay? But ultimately, we have to decide what the law is on this. And if your view is that he doesn't have a constitutional right to threaten someone in his driveway with a gun, then I take it that the threat can be an assault, can be criminally charged by Massachusetts, at least to your view.
Judge, I'll go a step ahead of you. I'm not suggesting that the Second Amendment protects anybody's right to point a gun and utter a threat while holding a gun. That's not what happened in this case. All right. This man stood in the doorway of his own home, having a right to hold that gun in his home. And
But now the problem is now we're arguing facts. We're not arguing law anymore. The reason I say that we're arguing facts is because I think the judge's view and the argument of the Commonwealth would be that holding the gun, as he did in the total facts of the case, was a threat, because he met him at the door without the gun, they had an argument, he raised his voice, he threw the thing at him, he leaves, he turns around, now he's got a gun. Why is that not a threat? Without any words, why isn't it reasonable for one to think that that is a threat, which is the question of law?
But Judge, your question presupposes that he wasn't required by state law, Chapter 140, Section 131L.
It does presuppose that, but you hadn't argued that yet. You just argued the Second Amendment. You hadn't argued the state law.
Well, you cut me off before I got there.
Okay, it's my fault. I agree with you. But let's back up.
Sure, I understand.
First questions are Second Amendment questions, right? Does he have a right to confront a person on his property with a gun?
Absolutely.
So as I understand it, you're arguing basically we cannot divorce Second Amendment considerations when we are considering sufficiency arguments here, whether it's at the motion to dismiss stage or otherwise.
Correct. And that argument, the common thread of my argument goes right through to the motion for required finding that was denied. But if I could finish the point that I started to make, and I appreciate your questions, Your Honor, obviously. There's an intersection here, or perhaps a conflict between Chapter 131, 140, I may have it backward, which requires, and I cited the case law, I believe it's Kentelly, Runyon, a few cases.
None of those cases say your guy had to go back and get a gun and bring it to the door.
No, but what they do say, Your Honor, is that if he's going to exercise...
If you have a gun that's out, it better be in your hands, is what you're saying.
Absolutely, Judge.
But he comes to the door, he comes to the door without a gun in his hand.
Yeah.
So, are you saying that was a criminal act that your client did?
Repeat that question, Judge.
He comes to the door without a gun in his hand. Was that a criminal act that your client did?
If he comes to the door without...
No, there's no if. He came to the door without a gun.
Correct.
That's what's happened. Was that a crime?
No.
Okay, so if that's not a crime, then he can come back to the door without a gun too, right?
Correct.
So why does it matter then?
Well, it matters because he has a fundamental right to possess a gun in his own home, and our state law statute requires that he either carry it or have it within the immediate reach, okay? That's exactly what we have here. And the notion that by somebody, whether he showed up to the door initially with the gun or reached for it later on, I'd suggest doesn't matter. He has a right to possess a firearm in case of confrontation.
I don't understand why that doesn't matter, because if someone's walking around with a gun on his holster, you got a holstered gun, you walk around all day, no one would think that was threatening. But if you suddenly went and got your gun in the middle of an argument, wouldn't a reasonable person think that was threatening? You were going to get it in the middle of the argument because now you're going to use it.
Somebody might construe it that way, but the issues that I'm focusing on, Judge, is the failure to consider the statutory requirement that he carry the gun or have it within arm's reach, combined with the constitutional right to possess a gun, goes to the question whether he intended to intimidate, to scare, or to threaten. And I believe the statute
Why isn't that a question of fact in the first instance for the judge to determine in the light most favorable to the Commonwealth under the De Benedetto standard?
Because it interferes with his Second Amendment right. And I'm not aware of any historic analog that suggests that a person cannot carry, possess a gun in their own home as they choose, when and why and where, within their own home. And that was never done in this case.
Right, but he's being prosecuted for threatening to imminently use a gun on someone. And there's certainly historical analogs of that, right?
Say it again, Judge?
You certainly agree there's historical analogs of people being prosecuted for assault with a gun back in colonial days.
Right, Judge. And in fact, I looked at the case law that was cited in Rahimi, and I think the Commonwealth relied heavily on their brief on it. And starting with Lengsvat, it's a case, somebody goes into a house with a raised gun, okay, clearly, that's a different situation. I'm looking at Commonwealth versus White, one of the earlier cases.
Why is that clearly a different situation? I mean, you know, there are a number of issues running around here, and we're jumping back and forth
Right.
between them, and that's not necessarily the best way for us to learn this. But let's just pause on, you say that's a different situation. I think for you know, Judge Neyman's question, for purposes of what a reasonable finder of fact could conclude at the probable cause stage, or for purposes of what would be what a person confronted with this would reason. Why is it different? A guy walks into a house with a gun like this, or I'm in an argument with a guy, he doesn't have a gun. I turn around, now he's got a gun. He's holding it. I mean, I think they're indistinguishable.
Yeah, I disagree. He's in his own home, Judge.
He's not in his own home. He's standing in his doorway. He may be on his own property, but he is standing in his doorway, and he is looking directly at someone who's not inside his house, but outside his house. He's not in his own home.
And he doesn't utter a single threat. The gun is pointed in the air.
Does that matter?
It does matter. There's no evidence as to what he's saying. He's yelling. He's yelling.
He could be yelling, "The Red Sox suck." I mean, he's got a gun that he didn't have.
But isn't it left to speculation, Judge, under the De Benedetto standard? Isn't that speculative? You know, there's no evidence as to what he's saying. He doesn't point the gun at the man. He's exercising.
It's a low bar, right?
I'm sorry?
Well, the bar for probable cause is not a high bar, right?
I understand, Jay. I'm very familiar with De Benedetto. I've argued those cases a number of times. But I know when a question as to a key element of an offense is left to speculation, and that's what I say under these circumstances, it's speculative whether there's probable cause in light of the Second Amendment right, in light of Chapter 140, 131L, whether there was an intent to threaten. And
Assume the exact same set of facts.
sure.
Except when the constable looks back, he hears your client say, "You're going down."
You got me there, Judge.
Sufficient?
I'd say that's sufficient.
So the question for us is whether or not, in essence, that is a reasonable inference drawn from the totality of facts here, which includes no gun, throwing something at the constable, throwing the papers at him, continuously yelling at him, and constable looks back, and now he's holding the gun. And the question is that capable of being interpreted in the light most favorable to the Commonwealth as evincing intent? That's where the rubber meets the road here, correct?
Yeah, I agree, Judge. And if I just correct you on one of your presupposed facts, constable doesn't say in the police report.
My facts aren't going to be presupposed. I will confine myself to exactly what the police report says.
Sure. And I believe the constable took that as he wasn't accepting service, not as him assaulting the constable or whatever. But if those actions, physical actions, were accompanied by a verbal threat, different case. It's missing here. Again, we have to engage in speculation, conjecture, and surmise to get there in probable cause.
Let me ask a different question, which I thought Judge Neyman was about to ask. The person arrives at his residence, comes up, and actually, this is very close to the facts of this case. Bangs on the window a bunch of times, bangs on the door, and your client meets him, gun lowered, and says, "Get off my property."
Legal.
Legal. Because even if considered to be threatening, protected by the Second Amendment.
Protected by the Second Amendment. Also, he has a right to tell people to get off his property. It's trespassing.
Well, but he's got a gun right here, right? And he can't cause imminent reasonable fear without running afoul of the state assault laws, right?
But Judge, isn't that why the Supreme Court in Bruin and Heller, talked about this in case of confrontation? One of the areas of argument I disagree with the Commonwealth is they presuppose that he didn't have a right to have the gun, that the only moment at which he had a right to have a gun was when the right of self-defense arose. And I'm not aware of anything in the law that says that there was an obligation to hide the gun because it might scare somebody, okay, or it might offend somebody.
Your time's expired, but you may continue, and we may have more questions. But all counsel should stop when the red light goes off. We, of course, will give you more time. Please continue.
Yeah. Your Honor, I'll touch on the other issues. I'm not sure I got back past probable cause. On the jury instruction, I'd like to be heard on that, and I'll be brief.
Go ahead.
I'll be brief. I made the argument before the district court judge that in order for the jury to fairly evaluate this case, and Your Honors are all familiar with the standard jury instruction, where one of the elements is proof of the defendant's intent. A jury is told that to make a judgment based on all the circumstances as to what the defendant intended, what was his purpose in engaging in whatever conduct was engaged in. And I argued to the court that the jury should be instructed that the defendant has a Second Amendment right to possess a firearm and a concurrent right to either carry it or have it within his immediate reach. The court refused to give that instruction. And my position was that had the jury considered those legal rights, it went right to the issue of what was his intent. Is he simply complying with Chapter 140 or 13140L?
Well, you asked for two different, see, the problem I have is you keep going back to that state law. I don't think the state law says what you, I personally, I have no idea what these guys think, don't think the state law says what you say it says, because the state law also says you can have it in a locked place, okay? You don't have to carry it around, you can store it. But you did ask for this. A person has a right under the Second Amendment to the United States Constitution to possess and carry weapons in case of confrontation, and this means that persons have a Second Amendment guarantee to possess and carry firearms either in their home or publicly in case of confrontation. And it's not accurate as written because they don't have a right unless they're licensed.
Right, and under Guardado, we have to, unless the Commonwealth proves otherwise, we assume people are licensed. In fact, I just read a decision in the past week that talked about even in a situation where somebody is a convicted felon, and it would seem to be a waste of time to give that instruction, the court said that it had to be given. The point I'm making,
Well, what
Judge,
case said that?
it was just public. I just read it in Lawyers Weekly last week, Judge. Just came
Not
down.
from our court.
I believe it was an SJC case. The headline in Lawyers, I just read it, I think, on Monday. The headline in Lawyers Weekly was they overturned a conviction where a gentleman was a convicted felon who, by law, could never possess a license to carry, and where the instruction wasn't given in that particular case, that the Commonwealth had the burden of proof to show that he was...
Oh, that's a burden of proof case. It's a burden of proof case. That's very different than we're not talking about burden of proof here, and we're not talking about possession here. We're talking about assault.
But if I could...
The difficulty I have is this isn't accurate.
I disagree with you, Your Honor. If you take a look at Kentelly and Runyon, look, in those cases, the defendant argued that the storage statute was an unconstitutional violation of the Second Amendment. And the court ruled, and frankly, this surprised me because I think it undermines the purpose of the Second Amendment, if you follow Bruin, that in order to comply with the storage statute, unless a firearm is in your possession, and they define that to be carrying or within immediate reach. That's the language that they used, Your Honor.
I think we understand that one, and yeah. I don't have
Anything further?
No.
We gave you an extra 5 minutes.
I appreciate
Thank
that,
you.
Your Honor.
No, well argued, we appreciate it, and we'll hear from the Commonwealth now.
Thank you very much, Your Honors.
Thank you.
Good morning, Your Honors, and may it please the Court, ADA Zachary Gruby for the Commonwealth. I'm joined at council table today by trial counsel Jessica Fleet. I think I'll start, unless the panel would like to direct me otherwise, with just the Second Amendment briefly. And so the Second Amendment, my brother didn't mention until 6 seconds left in his argument anything about this core principle of self-defense. He kept stating in his brief and during argument that it's in case of confrontation. But dating from Heller in 2008 and following the progeny, we understand the core of this right to be for self-defense.
I don't understand that. I'm sorry, go ahead, Joseph.
That's why it's in the Constitution, but the right is just to carry and possess guns.
Correct.
You don't have to be wanting to do self-defense. You could just want to have a gun on you, right?
Correct, Your Honor, but Heller specifically says this is not a right of citizens to carry arms for any sort of confrontation, and then it further goes on to say this is not a right to keep and carry any weapon whatsoever in any manner whatsoever for whatever purpose.
Mr. Howard has the right, assuming he's licensed, which I'm pretty sure he is, to walk around with his gun all day, right?
Correct, and that's why in my brief I state, you know, we may be in a different position had he went to the door at the first moment carrying this gun, because maybe Mr. Howard is just the type of person that when he's alone at home likes to carry a large firearm.
So we're going to draw the line at, let's assume the gun was within arm's reach right next to him. We're going to draw the line at, you have an uninvited person coming onto your property. If you open the door and you're holding the gun down and saying, go away, that's okay. But if the person, you start talking to the person, appears they won't go away, and you hold your gun down again, you're not pointing it at them, that's now a criminal violation? That's, I mean, I'm trying to think of a principled decision here.
Correct, Your Honor. And so I think there's a few very important distinctions in this case. The first is that although Mr. Howard might not have extended an invitation, this was a constable that was there by legal right to serve him with papers.
Stop. By legal right. It's in the briefs. Any evidence on that?
So it was testified to at trial by the constable that he was there legally to serve papers.
Well, he was there legally. I don't, so, I mean, and the reason I did that, stop, is because it creeps into your briefs, and it caused me to think, does it matter whether he's, quote, lawfully on the premises? And if so, did there have to be evidence to that effect?
So I think it matters when you tie in the other facts that Mr. Howard has been going through this divorce for 3 years. He's been served several times prior. He's very well aware of what this type of interaction is like. And so there is no evidence, especially when construed in the light most favorable to the Commonwealth, that this type of interaction would be surprising or inherently threatening or in any manner whatsoever. Instead, it shows that Mr. Howard, upon learning that this was someone here to serve him and upon being served, became angry, started yelling, threw papers past the constable, and then armed himself.
Can we just back up? Go ahead.
Where did the constable testify he had the legal right to go on the property? I didn't see that.
Your Honor, I don't have the exact citation, and perhaps he didn't say to that effect, but he did testify he was a constable there to make legal service.
Right, but constables don't have the authority, they don't have police authority to go into places. I mean, if he put up a sign that said, you know, no one can come in past my gate, constable can't go through the gate, right?
Correct, I would assume so, but there's no sign, or even from my understanding of the photos, admitted into evidence that there was a fence. There's no soliciting sign next to the door that can be seen within that evidence.
What's the law on that?
Your Honor, I'm not entirely sure the law about...
Is he trespassing? He's on someone else's property. Is he trespassing?
I don't believe so. I don't believe.
It has to be posted under our trespass laws.
Correct. And so where there's no posting, where he's just approaching a door to knock on it or to greet the person or to serve him with papers, there's nothing to indicate that he can't be there. And so when
Once he's told to leave, he's got to leave, right?
Correct, and he did leave upon serving Mr. Howard, and then that's when the confrontation escalates on the side of Mr. Howard. We see, or we hear from the victim, that he had considered Mr. Howard to be served after saying, "You can tell my effing ex-wife's lawyer," or whatever it is, what she can do. And so the constable testifies, "At that point, I deemed him being served. I took that as an admission of who he was. I served in the papers. I turned around. I was leaving." The papers then flew past him while Mr. Howard is screaming at him, and he turns around to Mr. Howard, now standing there, holding a gun like this.
Can we back up again? So this discussion of trespass and not trespass and lawfully on the premises, that was helpful to me. So now let's take the hypothetical. In the first instance, this constable, who has a right to walk up to the door and knock on the door, apparently, or at least, I'm not sure he has a right to do it, but it is not a crime for him to do it.
Correct.
Walks up to the door, knocks on the door, the guy meets him, he's got a gun in his hand like this, "Get off my property." Does he have a Second Amendment right to do that?
I think that's a very different question that I unfortunately...
That's his question, so please answer it.
So I'm not sure I have an answer for you. I think it would be a much closer call. I think people are entitled to carry a firearm as under current Second Amendment
Suppose
jurisprudence.
he meets him at the door, the gun is down, you're the constable about to serve me because of my blanking ex-wife, get off my property.
So I think the constable at that point has been told to get off. He's there to make service. I think any reasonable person in the constable's position would feel as if there's an inherent threat there, and maybe they would have left immediately.
Could he be prosecuted for assault, in your view, or does the Second Amendment give a constitutional right for the defendant to behave that way?
I don't think that the Second Amendment allows for that type of aggressive assertion upon learning that they're there to serve legal paperwork. I think when we look at the fact that it is limited in Heller by saying this isn't an absolute right, that you can't carry it for any manner whatsoever for any type of confrontation, and when someone is there to effect legal paperwork, I'm not sure that that's the type of confrontation that is enshrined.
So the line is drawn when the homeowner could no longer reasonably believe that the person who he's confronting is there for potentially unlawful purpose, potentially a purpose. See, you follow where I am? Because I think this case, I think these issues are playing at least around the edges of this case. I understand the argument that those aren't our facts because he didn't have the gun in the first instance. He went back and he got the gun. I get that. But the Second Amendment's been raised, and trying to draw the line is not readily apparent to this judge.
And I agree. When I was writing the brief, I was thinking there could be any number of hypotheticals that possibly could change the outcome. But when looking at these scenarios, it is an intensely factual specific inquiry. And my brother in his brief cites to a case saying it's the jury's determination as to whether or not he intended to use it for deadly force. But when you actually look at that case, it was dealing with a request for a self-defense instruction for deadly force, and it specifically differentiates in footnote 5 whether or not it's an element of a crime versus whether or not you are asserting it for self-defense purposes.
Let me try it this way. So for an assault under the threatened battery theory, you have to put the victim in reasonable apprehension of an immediate battery.
Correct.
So where's the immediacy here?
So
Why would someone think that he's going to shoot, going to shoot the constable at the time that he sees the gun?
when considering these facts in favor of the Commonwealth, Your Honor, and frankly, in any light, I struggled to come up with any legitimate purpose to arming himself at that moment except to exhibit this threat. And I think when you couple that with the fact that the constable was already turned away and walking back to his car, and the service papers, which is what the constable was there to serve, flew past him, an inherent reasonable inference that you could reach is that he armed himself with the firearm and was yelling at him after throwing those service papers to signal, if you pick those papers up or if you try to serve me again, then it won't just be pointed at this guy, it will be pointed at you. Because those documents are inherently tied to why the constable is there.
So the immediacy is, you'll be immediately shot if you do what I don't want you to do.
Correct, or if you stay on the property, or because you were here and I'm angry at you. We see evidence of the defendant's ire and—
Or if you come back and try to reserve me with the papers I just threw at you.
Correct. I think that that is inherent.
That's problematic, because that doesn't seem too immediate. I mean,
right, but I think—
I'm going to shoot you if you don't. Keep going. I'm going to shoot you if you try to return that envelope. I see the immediacy there. I'm going to shoot you a week from now when you come back to that seems like a threat to commit a crime, not an immediate battery, right? I mean, am I missing something? Would that be an assault? If you put someone in fear that you would shoot them in a week?
I think it would be more on the line as to whether or not it was an immediate battery, but I do think where someone is actively yelling at you, they've already thrown the materials you were there to provide, they're saying essentially, effectively, I don't accept service, and it's your job to perform service. You're now left with this choice. Do I pick up these documents and serve him as I've been hired to do? And if so, is he going to shoot me, or do I flee? And so I do think there is an inherent threat of an immediate battery here. I do think that it was entirely reasonable that the victim felt this way. He testified, I felt as if he could drop, it would take nothing for him to level that firearm at me in an instant, that showing the weapon at that moment was a threat, that he felt afraid, that an officer that arrived on scene soon after testified that he was trembling and shaking. I think when you look at the fact this is a 76-year-old man that does not have an imposing stature, that served this man with these documents, these are all legitimate reasons that don't give rise to grabbing a firearm at that moment. I just don't think that there's any legitimate purpose outside of sending this signal, do not come here.
So you're seeking a very narrow holding in a very fact-specific scenario, it seems.
I think that
because if this case were, let's say, on the docket in the U.S. Supreme Court, and the facts are, or the summary is, man with license to carry, holding gun and threshold inside of his own home can be convicted, is not protected by the Second Amendment, even when not pointing the gun at anyone else or uttering any threat. I think we would know where that case would go.
I think so, Your Honor, but I think what was not discussed in my brother's brief is that to even reach Second Amendment protection, you have to answer the first question that the conduct is protected by the Second Amendment in the context. And assault with a dangerous weapon is a heavily contextual analysis. And when you're trying to determine it, you're not looking at the defendant's secret intent. You're looking at the objective
manifestations,
and the apparent ability to injure. And so in this instance, by showing up to the door without being armed, and only after learning why the constable is there, that's when he starts raising his voice. That's when he starts getting angry. He throws the paperwork. He grabs the firearm. I don't think that there's any other reading, especially in the light most favorable to the Commonwealth, that he legitimately armed himself for any innocent or innocuous purpose. It was there to send a message. I see that I'm about to expire time. If I could finish my thought.
Thank you.
Hope you're not about to expire.
Thank you for asking, and yes, you may continue.
Thank you. I think when, especially looking at the 911 call made by the defendant in this case, he states things such as, "I'm just sick and tired of my rights and my privacies being stomped on." He refers to the constable towards the end of it as a threat, or the threat has been neutralized now that he's off his property. He talks about all the ways that he's angry at the ways that he's been served in the last 3 years, because he says that these constables are laying in wait to ambush him in front of his children, and he acknowledges that in this case the constable did not do it in front of the children. And so all of that shows you and is relative to this determination of why he armed himself in that moment, and whether or not it's a justifiable anger that after a 3-year contentious divorce you are frustrated at being served. It remains that this objectively menacing conduct in the middle of an argument and arming yourself with a large firearm is meant to intimidate or threaten.
I have one.
Final question from Justice Englander.
Did you have one? No. Judge Ditkoff? What about the jury instruction? Why shouldn't the jury be told a person has a right under the Second Amendment of the United States Constitution to possess and carry weapons? And this means, forget about the words "in case of confrontation." Although maybe we shouldn't, because maybe the question is as simple as it has to be accurate in order for them to win, and this is not completely accurate?
Correct, Your Honor. So I have a few different thoughts about it. I do think that it's an incomplete jury instruction as is. It places no limitations on this right. It doesn't say that it's contextual. It doesn't define anything further. I also think that under our current jurisprudence, a judge doesn't have to give a requested jury instruction as long as what's given as a whole.
Yeah, but the Second Amendment isn't mentioned.
Correct, because I don't think that this right to possess a firearm is inherent in an assault with a dangerous weapon. We're talking about the conduct.
Yeah, see, that's where you lose me.
Okay.
I think there very well could have been an instruction asked for, crafted properly here, that it would have been reversible error for my view, it would have been reversible error for the judge not to give. And it's not reflected in your briefs at all. But it goes to this conversation we're just having, which is that there's some constitutional right, some level at which this person can be armed and meet somebody at the door who they don't know who that person is. Okay? And they have a Second Amendment right to do that if they are licensed to carry that weapon. I don't care that the Commonwealth thinks it was an assault, because the defense is, no, it wasn't an assault. He's just exercising his Second Amendment rights. And the jury should have been told that if it was crafted properly. What's wrong about my view on that?
I don't think there's anything inherently wrong with it, but I think that the instructions for assault with a deadly weapon or a dangerous weapon inherently encapsulate that as a defense. You have to look at whether or not the defendant intended to place him in imminent fear and whether or not that was a reasonable belief.
Don't you think the Second Amendment is a completely different dimension than anything else you're talking about there? There is a constitutional right to behave in the way that this person behaved up to a point. Don't you think the jury needs to be told about that?
I think it's appropriate to be screened perhaps at the judicial level. I'm not aware of cases where we give jury instructions about the Fourth Amendment right, where the defense is potentially saying that a search or a seizure of an item from a defendant is not good. And I don't think necessarily that any time that a firearm is raised, you get instructed on the Second Amendment right. I think that you have to look at the instruction given as a whole.
Okay. I take the point. Thank you.
Thank you.
Okay.
Excellent arguments. The case is under advisement, and we will take a no more than a 10-minute recess.
All rise, please.
Going the other way, big guy. We're on 4.
Court is now in recess.
Nice to meet you.
All rise, please.
Lovely to see you. Lovely to see you too.
And it's still morning, so good morning. Calling our fourth case on the list, docket 24, P1260, Department of Children and Families versus Father. I remind counsel that this case is impounded, so please refrain from referring to any impounded information, the children's names, etc. And we'll hear first from counsel for Father.
Good morning, Your Honors. I had to check the time to be sure. It was morning still. May it please the Court, my name is Lynn Alderman Boyer, and I represent the appellant Father. I'll be arguing for 15 minutes. And I'd like to start with the reasonable efforts argument in my brief. So reasonable efforts by the department are statutorily required prior to terminating the rights of a parent, unless there is an exception which doesn't apply in this case. And the department's own regulations require that DCF shall make all reasonable efforts to work in cooperation with incarcerated parents to promote a healthy relationship with their children and to avoid permanent separation. Specifically, 110 CMR 1.10, special provisions relating to incarcerated parents, states, the department recognizes that special efforts required to prevent permanent or irremediable separation of children from their incarcerated parents. Therefore, the department shall make all reasonable efforts to work in cooperation with incarcerated parents to promote a healthy relationship with their children and to avoid permanent separation. The department.
I just have one question about
Yes,
the
Your Honor.
reasonable efforts argument. Child and DCF say was not raised, therefore it's waived. You acknowledge that it was not specifically raised, but you say it's always an issue before the trial court. How do we reconcile the two?
Good question, Your Honor. So I do want to state that I did find 2 cases yesterday. I have not been able to file a 16L letter yet. So what I would say to that is that, yes, we acknowledge that there is case law that talks about a waiver if reasonable efforts are not raised. This situation
Counselor,
involving...
talking just the early part, before this, so that he's incarcerated at the beginning, then he's incarcerated starting September 2020. Just talking about the early part.
Yes.
What duty does DCF have when someone is not a adjudicated father, not on the birth certificate, to provide service? I know they generally do provide services, but what duty do they have to provide services to a non-father?
So, correct, Your Honor, this father was not adjudicated right away. The record does not appear to show that there was any doubt that he was the father. The department did actually give him an action plan while he was in prison, and so there was 11 months of incarceration, basically, in 2 different separate incarcerations, and then there was one third one that was about 2 weeks, which really didn't interfere with much. In the first incarceration, which went from November 2021, the child was in bond until December 14th of 2021 to July of 2022. The father had not yet been adjudicated, the actual father, but the department was treating him as if he was the father, in the sense that, although it did take them 3 months to get to the prison, they did arrive to the prison eventually by phone. He was given an action plan. And I want to say the action plan was given to him around March. There were 2 phone calls by the social worker in March and May. The action plan that was given then was pretty boilerplate, meaning that there were definite tasks on there that the father could not complete while being in prison. Things like having visits, bringing toys, bringing bags, calling the department at 5. Visits weren't even being discussed or planned. Certainly the father can't do that in prison. The father was adjudicated to be the father of
I
this
guess
child.
just to go back to Justice Ditkoff's question,
Yes.
do we have any cases stating that DCF must make reasonable efforts to a parent before they are adjudicated as the parent?
That I don't know, Your Honor, to be completely honest with you. I can only say that at the time the department was holding themselves out to acknowledge him as the father in terms of actually providing an action plan.
Yep.
By the time
I'll ask the same question of opposing counsel as well.
Of course, Your
So
Honor.
you can,
So I do have to say, like, and I do this as trial work too, and in this case, like, looking at it, the department did definitely treat him as if he were the father. He could not be on the birth certificate because he was in prison when the child was born. It did take some time, I believe it was July.
Why can't you be on a birth certificate if you're in prison?
He wasn't present in the hospital, so he was incarcerated, so he wasn't on the birth certificate.
You can't put someone on a birth certificate at a hospital unless they're physically present?
That's my understanding, Your Honor. I don't know specifically if there's any way that the prison would make some accommodation for you to be at a hospital, but in this situation.
I've never heard that.
Yeah, in this situation, he was
They
incarcerated.
just ask the mother who's the father, and she writes it on the form, and then they create the birth certificate from that.
So acknowledgement of paternity is definitely an option, as long as both parents can do this. I don't know the specifics of why that wasn't done, Your Honor. All I can tell you is that he was eventually, it was July 10th of 2023, that he was eventually adjudicated the father. Not certain why it took so long, but he did go through the testing. And in the second incarceration, technically the third, the second one was about 2 weeks, he fully was adjudicated the father, and the same issues occurred. So there was no visits initially, and
what's the record say about that? I mean, is there, so it's asserted by your opponents that I never asked, okay? And you would say, well, it doesn't matter. But is there anything in the record that, because when he was out of the prison, the department was working with him to get him visits. Is there anything in the record that tells us why there were no visits when he was incarcerated?
there is nothing in the record that I could find that talked about that. There is.
Well, what about, as far as the second incarceration, the social worker testifies, the times I had gone to the House of Corrections to visit with him, he had upcoming court dates like a week or two after, and he anticipated on being released. So there wasn't any ask for visits at that point. We just planned to resume upon release. And he testifies at trial that he thinks he's going to be released in 8 days. So this is only the second, not the first. But for the second set, don't we have the evidence that the reason was because he keeps saying, no, I'm going to be released any day. So why would you arrange a visit in jail under that circumstance?
So, Your Honor, the reason, what I would say to that is that reasonable efforts is extremely important in these cases. We're talking about termination of parental rights, and abiding by an action plan and visiting with your child is extremely important. When you don't visit with your child, it's a reason for termination. And the department has this statute that literally says that they shall make all reasonable efforts to bring a child to a prison to visit. And the way that I would answer that is that if it is a law, it's a regulation. This social worker did not ask, he admitted it. I did not ask ever for if he wanted visits with this child. And I can just say, representing clients, that sometimes people don't think they can have visits. Sometimes they don't bother to ask. But this is the Department of Children and Families. They're obligated by law to make this happen. And
even if the person says, I'm going to be out of here in a week.
Absolutely. I think the onus is still on the department to say, we are required to give you, visits, and do you want them? I believe the father testified that if he had known, he would have loved to have seen his child. In fact, he went to almost all the visits. There was never an issue with visits. He did very well.
Well, doesn't the record also show he had no visits with his older children while he was incarcerated?
His older children, I think his oldest was 30. So these were older.
What he said is, I didn't visit with my older children. In other words, I don't know what the circumstances were, but he never met with his kids while he was in prison at any time. He's been in prison all his life.
So, Your Honor, what I would say to that is that I still believe the responsibility is on the Department of Children and Families. They're obligated by law to try to facilitate visits. And I think that the Department of Children and Families is a big organization. These parents
What's the record that shows that they knew where he was during this time?
Well, they did know because it's in the record. It's in my brief. exactly when they called him, when they finally met with him. In their court reports, they're pretty specific about the action plans. In one of the court reports, when he was in prison the second time, they said that he's in prison, he's in prison, he's in prison. So they never gave him tasks that he could actually do.
It was hard. I couldn't figure out when and how they learned he was in prison the first time. Obviously, they must have known by March because they contacted him.
I believe they knew.
Maybe I missed in the record. I didn't see in the record where it said how and when they learned that.
So I'm not sure if it's very clear. They may have learned it from the mother. The mother may have told them because they knew where she was. So it probably came up in that realm. But I would say that, you know, when you have someone in prison, they have a special provision. It's specifically called a special provision for incarcerated parents. Parents who are incarcerated are still parents. They still love their children. They still want to have reunification. And I believe that it's up to, according to the statute, it doesn't say a parent should ask you first. It says that they shall provide visits. And I think, according to the statute, it's a law that should be happening. Regardless of what's happening with your client, you should be asking, do you want visits? We are obligated to provide visits. Can we set you up with a visit? There is no evidence that that ever happened. In fact, the department acknowledges that they knew that he was in prison and that he really couldn't have tasks that he could do in there by actually writing their court report. You know, they have the tasks listed for the action plan. He's in prison. I think one of the social worker even says, oh, you can do a substance abuse program when you're out of prison. So there is this, and I could just say honestly that for people that are actually in prison, it is a special circumstance because you can't leave the prison. They had the Nurturing Fathers program on there. How can someone do the Nurturing Fathers program?
It goes back to what I was suggesting earlier, which is you give an action plan, all this stuff that you can do when you're out of prison. And when you do that to someone who says, I'm going to be out of prison next week, why is that unreasonable? Why would you give someone a plan just for the next 5 days?
So when father was in prison both times, so I guess we can look at the first time too, if you would accommodate me that, the clock is ticking and DCF knows this. We know that there's going to be a trial. This is how this works. You get a case, it comes in, and you know that in about 1.5 years or 2 years there's going to be a trial. A parent is going to be asked, did you abide by what's on your action plan? And if you don't, that's a problem. That's a reason for termination. If you don't visit with your child, that's a reason for termination. In fact, this judge in conclusion 7 literally said, father did not visit with his son in prison. That was used against him. They're social workers. It's the Department of Children and Families. So you say to your client, I highly advise you to, let me give you an action plan that you can access. And in that prison, and I wrote this in my brief, they have so many services. I mean, it's incredible the amount of services. It's their duty to go in there and say, let's do an action plan that you can access. But when you have an action plan that a parent cannot access because they're in prison, such as having a visit at your house.
But why is that unreasonable when you think he's going to be released next week?
Well, Judge, he doesn't know he's going to be released next week.
He keeps saying that. Why would the social worker think that he knows better than the father?
I would absolutely think a social worker, even if he was being released in a week, well, first of all, we don't ever really know that. But even if he was being released in a week, I would think that a social worker who works for the Department of Children and Families, who's educated and who has a legal obligation to provide visits and also an action plan, and the department in their policy says that this is an action plan is a living document. It's supposed to be updated. It's supposed to be worked on together. That does not relieve the department. Too many times we see the parents getting the blame for DCF not stepping up for what they're supposed to provide in reasonable efforts. And I would say that this is a special class of individuals that can't access things off of an action plan. If it's not something they can do in the prison, they can't access that. But when it comes time for trial, they certainly will be judged on that. And so the Department of Children and Families has a legal obligation to make sure that that happens. And I would just, I don't know if you want me to stop yet, but I know it's yellow.
Until the red light goes off.
But I would say that also the two cases that I came across that I just wanted to bring up to the court that I found to kind of talk to the waiver would be adoption of Mary, which states generally issues not raised by a losing party in the trial court are not addressed on appeal, absent exceptional circumstances, and then Commonwealth versus Randolph.
So adoption of Mary, what's the site, please?
This site is 414 Mass 705.
Thank you.
1993, and then Commonwealth versus Randolph, which is 438 Mass 290. 2002, and that one says the doctrine of waiver incorporates a number of exceptions, including when failure to consider an unpreserved issue creates a substantial risk of a miscarriage of justice. And I would just argue, when you don't have an action plan you can access and you can't see your child for 11 months and then that's a reason to terminate your rights, I think that is a substantial miscarriage of justice.
Thank you.
Thank you very much.
Well argued. We'll now hear from, I believe, first from the department. And you're dividing your time 10 and 5, correct? Thank
you. Good morning still. Tracy Corral for the Department of Children and Families. May it please the court. I will skip right ahead to the reasonable efforts arguments.
So is there authority either way for determining whether or not a parent, or I guess a putative parent, pre-adjudication of being the parent is entitled to reasonable efforts?
Your Honor, I would say that I'm not aware of any authority. I think in all fairness, the department can't be held to account for servicing parents who are not on the birth certificate as parents. In my many years with the department, we have in good faith worked with parents who we believe are the parent while they're going through the process of getting adjudicated the parent. But in this case, we do have a pretty substantial period of time in which this gentleman was not adjudicated the parent. We also have, and it's important to keep things in context, the question of bringing, at least for the first incarceration, the question of bringing a child to the House of Corrections during the tail end of the pandemic, and with a father who was not adjudicated. So I think that is something that should be considered here. And that would bring me to my next point.
Wait. So you're suggesting that in May and June of 2022, because of the pandemic, DCF wasn't doing visitations in prison?
I'm not making that suggestion, Your Honor. What I'm saying is that, and actually this brings me to my next point. The department, well, there was no motion practice around whether or not the department abused its discretion or what was going on, why there were no visitation, why there was no visitation during that first incarceration. So as Your Honor pointed out, it could have been that father kept saying, I'm getting out next week, or that he declined visits. He says it would have been nice to have visitation, but that he did decline visits, or that the House of Corrections was not providing visits. We just don't know. There were a number of different factors that could have gone into this, and this is why.
What do you say to the waiver point?
Excuse me?
What do you say to the waiver point? I mean, it seems to me that description of the facts leads right to waiver.
That is exactly where I was going, Your Honor.
Well, see?
Your Honor, that's why it's important that these get looked at the trial court level, that it creates a record for Your Honors to review, that we're not trying to guess at what the facts were surrounding whether or not there were reasonable efforts being made by the department, because there could have been any number of explanations, and sure, one of the explanations could have been that the department wasn't doing what it was supposed to be doing, but as I said, there were any number of explanations that could have accounted for the department not providing visitation, at least during that first incarceration. So I think in this case in particular, it's very important that that motion practice happened and the facts be explored.
Okay, so but what about second incarceration? Because the first incarceration, I can't remember how long it lasts, 5 months or something like that.
Yes.
The baby's very, very young. And then he does start to see the child on a regular basis, right?
Yes.
For long enough that the department is actually prepared to have him take the child.
Yes.
And then he goes back to jail, and now there are no visitations. What about that? What are the explanations there?
Well, I think Judge Ditkoff did allude to it earlier in that the social worker did testify that every time he spoke to the father said he was getting out in a matter of days, weeks. He routinely said that he was not going to be in there for very long. So the same logic would apply to the second incarceration in terms of waiver, that we don't know why visitation didn't happen, and that may well have been a factor. I would also like to point out to your honors that the department did not learn about father's incarceration until after the fact. Father dropped out of contact with the department in July. He did not.
How long?
The department got in touch with the father.
The whole incident with the SWAT team and.
Yes, but
So
the
he's
department.
being held in part pre-trial, right?
Correct. Well, that's the other
Two
question.
different components to it, as I understood it.
Right, and the department did not learn about the SWAT team incident from the father. It learned about that situation through social media and also through his probation officer.
What does the record tell us as to how long the department was unaware of where he was?
Unfortunately, I cannot remember that right now. I can submit a letter, Your Honor, and let Your Honor know. I just don't have it off the top of my head. But I just want to reiterate that before I move on to the other piece of my reasonable efforts argument, I would like to reiterate that it's in this case in particular where there are a lot of facts floating around regarding what father said, what father didn't say, what was going on during the first incarceration, what the House of Corrections was providing during the first incarceration, and father's adjudication. These all could have been fleshed out had there been a motion filed, and there was no motion filed, and it was waived. And I think that in this case in particular, waiver is a valid argument in terms of a reasonable efforts argument at the appeals court level. But I'd like to move on to the second piece, and that is even if you were to decide that the argument was not waived or that it should be considered by this court, the department did make reasonable efforts here. First of all, I believe it's footnote 14 of my brief. I allude to father's brief in which he lists the number of services that were available to him through the House of Corrections. If you look at the length, and probably one of the most crucial services the department was asking the father to do was the substance abuse treatment, and those things were available to him. There was the service.
How does that, I mean, the argument is you didn't provide visitation with the child.
I don't believe that, I agree with you that visitation is a crucial service and that the father should have had visitation if he was interested in having visitation with his child. I'm not going to argue that point. But the question here is whether the father, and I think it's important to remember that father had relapsed on cocaine in July. That July incident where he was nude in his apartment complex when there were harassment orders filed and so forth, and new charges, he had relapsed on cocaine at that point. And his mental health had started sliding at that point. And so those were the services that were going to bring him to reunification with his child. He was having visitation while he was out of jail. He was having consistent visitation, and the department was asking him to engage.
What I said goes both ways. He's not doing services at the house because he thinks he's going to be released momentarily.
That is true, but the question is whether or not the department made reasonable efforts, and the department asked him to do substance use substance abuse services, both while he was incarcerated and after he left the prison. And he did not do it. He declined. He declined the substance use services, he procrastinated the therapy, and he declined nurturing fathers while he was out of prison. And where that led us was where we found ourselves in July of 23, when he was both exhibiting signs of having mental health issues as well as a relapse on cocaine. And that led us to the September situation, where he was most certainly clearly having mental health issues at that point, and also the question would remain whether or not, since he hadn't had any kind of treatment for the cocaine use, whether or not he was also still using cocaine. And that's what prevented the reunification in this case, was his relapse into the criminal behavior, his relapse into cocaine use, and his relapse into mental health issues. And, Your Honor, the question before this court is whether or not the trial court had abused its discretion in finding that the department made reasonable efforts, whether it abused its discretion in finding that father was indefinitely unfit. And in this case, the evidence supported a finding of reasonable efforts, because the department did work with father and try and get him those services that he needed. And and I'm sorry, my time has expired.
And I think we'll have to leave it right there. Thank you very much.
Thank you.
And counsel for the child.
Good day, Your Honors. Jennifer DeFeo. I represent the appellee child, and on his behalf, we are requesting that you affirm the juvenile court decision to terminate his father's parental rights. I know a lot of what we've talked about this morning has been the reasonable efforts. I do want to point out that in adoption of Alona, the court states that it may determine that the department has failed to meet its reasonable efforts obligations, but nonetheless determine that a parent is currently unfit and commit a child to the department's custody, even if the court concludes that the reasonable efforts weren't met, but it's in the best interest of the child to do so. Because in it all, no matter what we look at, the best interest of the child does supersede everything else. I think in this case, we have reasonable efforts had been made. Father, for the most part, spent the last 20 years in and out of prison. He himself testified that he did not visit with his children while he was in prison. And he testified he had a 5-year-old daughter at the time of trial. So it wasn't even this child who was young. There was a 5-year-old also involved who he did not.
I don't really get that, because he doesn't get to go visit people while he's incarcerated. They have to come to him. And I thought all the other ones are relatives or guardians of that sort who get to choose whether they want to bring their child into the prison to see him. Certainly the 30-year-old. Like, how does he choose not to visit while he's in prison?
That was his choice, Your Honor. He testified.
How is that his choice?
He didn't testify, I was denied the right to visit with my child. He testified, I do not visit with my children in prison. And I think that the way he stated that was it was an affirmative choice on his part. And also, when the social worker who met with him monthly testified, as yourself indicated, that they both sort of believed that Dad was going to get out in a couple of days, in a week, and that there was no purpose to start visits at that time. But we also have trial counsel involved in this. There's been no ineffective assistance of counsel motion filed. There was very briefly a motion for visits filed, and for whatever reason, it was withdrawn. The record is not clear as to why it was filed, who filed it, and why it was withdrawn. So this isn't something that was a surprise that Father had the ability to do this. He just didn't do it. And I think that if you look at the overall factual basis here, Father just kept saying, I am getting out. I am getting out, and I am getting my child back. And even when it came down to looking at competing plans, is there anyone else who you would like to step in? His attitude was, no, I am getting out. I am getting custody of my child back. So while he did the day of trial suggest his girlfriend, who had her own long history of drug issues, which is how he became involved with her, his attitude never wavered. He was not going to offer up anybody else on a serious basis because he himself was going to parent this child. What we also have, Your Honor, is that the judge made it clear that the incarceration piece, although it did impact his visits, was only one factor in the global picture here. This man has 22 pages of a criminal record. He has charges for drugs, violence, open and lewd, gang activity. We are not talking about someone who just had these compulsory motor vehicle issues, which is what arose in 2023 before everything sort of decompensated on his behalf. We're not looking at somebody who is safe for this child. I don't think there's any doubt, based on what happened in August, what happened with SWAT, that this child would be at great risk of peril if he were placed in father's care. He is very bright, this child. I had the pleasure of meeting with him. He's articulate. He is, while I'm not a bonding expert, I know it was very briefly touched on, that the judge made a decision that there was an attachment and that could have been erroneous, but that wasn't a decisive factor. I think that the facts in this case are overwhelming. That father was unfit. Currently, and based on the prognostic value of everything else that has been discussed, he would continue to be so for an indefinite future. I do see that my time is up. If there are no further questions, I will rest on my brief.
Seeing none, thank you. Parties have been well represented, and the case is submitted. Thank you. Calling our fifth case on the list, docket 23P1131, McDonald v. Kazokas. And there is some overlap, obviously, between this case and our next case, 24P923, but we are having them argued separately. We'll hear first from counsel for the appellant. Good afternoon.
Good afternoon, Your Honors. Peter Viteri from the law firm of Verrill Dana in Boston. I'm here representing Ken MacDonald and Jody MacDonald, both of whom are in the courtroom today, have taken time out of their days to attend.
Thank you.
As you mentioned, there's two appeals, two different cases that are being heard separately. They both involve wetlands permitting. They are separate because there's really two different paths for wetlands permitting, one under a local bylaw, one under the State Wetlands Act. This first case is under the local wetlands bylaw. I can give the court a brief description of the project. Basically, the appellant, Mr. McDonald, Mr. and Mrs. McDonald, they live at 42 Shagbark Road in Littleton, Massachusetts.
It's totally up to you to use your time as you see fit, but we know the facts of this case quite well.
Very well. I'll begin then. The key provisions of the Littleton wetlands bylaw and regulations, this involves a no disturbance provision, which basically prohibits any work within 50 feet of a wetland resource area. And that's at section 4.2 of the regulations. It's in the volume 1 of the appendix at page 39. The bylaw or the wetland regulations also provide for a waiver of strict compliance with any provision of the regulations if certain conditions are met.
Well, let's get to the third prong, if you will, the waiver with regard to the least environmentally damaging practicable alternative. If that didn't say practicable, I would have more problems with it. But the addition of the word practicable, how does that impact your case here?
Well, I think it's very important, I think, to distinguish between the features of the property. The project, part of the project, in addition to renovating a house and installing a septic system, was upgrading a dirt cart path on the property into basically a second driveway. And I say a second driveway because there is an existing driveway that serves this property. And the property, if you visualize it, it's sort of a long, thin rectangle partly on the pond, and the second driveway comes from the south, and Shagbark Road kind of cuts through the middle of the property, and the cart path comes off of Shagbark Road. That's right.
We got it.
Right. So that existing driveway from the south that's closer to the pond, that comes off of Cottage Way. That road is generally paved and comes onto the property, and that's the main access to the property. I'll point to Volume 2 of the appendix at page 201 and 202, where you can see pictures of...
Are there photographs of the road?
Yes, these are at the, these are the citations.
Who put the photographs in?
The photographs of the road come from Mr. MacDonald, and the comparison photograph of the cart path, which is at Volume 1, page 57, that comes from the Conservation Commission during their site visit.
And one of the difficulties that I had reading the briefs is almost a ship's passing in the night feeling with respect to the facts. I mean, to the point where you get to your reply brief and say, Cottage Way gives is in excellent condition. I think you use the word excellent. I can't remember if it's excellent condition or it's excellent access, which is not what was found by the Littleton Conservation Commission, right?
I mean, that's correct, but it's also not what's required under the regulations. As Justice Neyman said.
Well, let's stick with the facts first. Mm-hmm. I mean, does it give excellent access, or does it give access that is such that the fire chief, as I was reading a difficult transcript to read, seems to suggest there's some problems here. There are some tight turns. It's a narrow road. We couldn't get a full-size fire truck down Cottage Way.
I don't think...
Therefore, we'd come in from both directions if we had a significant fire. Isn't that what he testified to?
I don't think so. I think what he testified to in terms of not fitting fire equipment down there was the cart path when it's upgraded, as proposed. I think what he testified...
Why the reference to coming in from both directions, then?
I mean, he said that's what his preference would be in fighting a fire, would be you want multiple points of access, as much access as you can gain.
That is not what he said, counsel. Be careful.
I believe what he said about the existing...
If there were a significant fire, we would probably use both routes. That is not saying my preference. That is saying we'd have to come in from both directions. Am I misreading it?
I don't think he says he has to. I think he says we probably would.
Right.
And I don't think he says that it's necessary.
We would have to get smaller engines down there. That's his answer to the question about access on Cottage Way. Smaller engines down there. We wouldn't be able to. It would be a little bit more of a challenge to get some of the other apparatus in.
He also says...
Am I reading that incorrectly? Does that sound like excellent access to you?
I don't think that excellent access is the standard to be held to.
No, but see, that's why I started where I did. I'm sorry to be difficult, but when I read two briefs that factually, literally don't touch on each other, and I think it's a problem for both counsel, then I have to try to figure out what the heck the record means. So I went to the record. You said in your brief, it's excellent. That doesn't read like excellent to me.
Well, I mean, the regulations don't require excellent, though. They require practicable.
Okay.
And so
you don't think I'm misreading what I'm reading here, then?
I don't have it in front of me, but I trust that you're reading it correctly.
Yeah, he used the word okay. That I saw, and that you emphasized in your first brief. Your reply brief seemed to me to literally go in a different direction. Okay, all right. Sorry.
And so, I mean, that gets back to what the standard is practicable. There is a practicable. There's okay access. There's testimony from a neighbor that says that access on Cottage Way was used by the fire department in order to put out a fire in the neighbor's garage. And that's the neighbor next door to the locust, next door to Ms. Kazokas.
Tropiano?
Yes.
Who said that I wouldn't trust a truck over 8,000 or 9,000 pounds to go over it, which is a blockage for her?
Well, he's referring to a culvert in the road which is before his house. And so the trucks, when the fire department went down there,
He said a blockage for her.
I think he's referring to, like, for the culvert on the road. And, I mean, she lives on the other end, like, past his house on the same road, right? But his garage is also past that quote-unquote blockage, and the fire department was able to get down there without an issue.
It's strange that the neighbor and the fire chief both tell us you can't get big engines over down there, and you're telling us that the commission couldn't believe that.
I don't think that's what they're both saying. I think the neighbor says that there was a fire and the fire department was able to put it out, and the fire chief says the access is okay.
He says it's okay, but if it was a big fire, he couldn't get a small apparatus down, he couldn't get a large apparatus down there, and he'd have trouble. He would want to go from both directions to put out a big fire. I don't know the fact that there's a single fire that was okay really gets you anywhere. Why? What am I missing?
I think what the fire chief said is that having two routes and having the cart path be upgraded in order to fit the equipment would be preferable, but I don't think he says it's strictly necessary, which I think is it's not the third prong of that waiver provision, but it's within the first prong of the waiver provision, which discusses necessary to prevent a safety hazard. Now,
why isn't it in the public interest, which is what the commission found,
well,
in a highly forested area, for it to be possible for the chief to fight the fire the most effective way he wants to?
I mean, the commission used public interest, but the factors that they listed don't relate to the public interest. When the appellees define public interest in their brief, they say related to the general welfare of the populace of the town. Now, the only really rationale that relates to the general population and not just the individual lot owner is the access for emergency vehicles or fire vehicles, but that's necessary to prevent a safety. That's a public safety issue, not, I mean, I guess there's overlap with public interest.
I don't see why it's not. Why is it not in the public interest to keep this whole area from going up in flames?
I mean, it certainly is, but it's also a safety hazard, and the provision says public interest, and it says necessary to prevent a safety hazard. I would say, if you're talking about fire safety or emergency vehicles, that falls into the necessary to prevent a safety hazard language and not in the public interest one. I think public interest will relate to other matters of public interest that aren't safety hazards or preventing a safety hazard. I think that's a way to read the regulation without adding superfluous language.
So when we're talking about fire safety, it has to be necessary.
Correct.
And we ignore the language about public interest, which, as Justice Ditkoff just pointed out, it would be in the public interest to, even if it's not necessary, to have better access for fire trucks.
I would say that anything related to public safety or preventing a safety hazard falls within the clause,
language.
And therefore has to be necessary, yes. And other matters that might relate to the public interest, for example, maybe something relates to, the pollution in the pond or something like that.
Could it be read differently? I worried about this a little bit. Could it be read differently to be saying, you can do what's in the public interest, but just to be clear, if it's necessary for safety purposes, you got to do that?
I mean, I think there's an or clause in that provision. There's or between all of those ones. So it's either in the public interest or it's necessary to prevent a safety hazard. And if you're talking about emergency vehicles and things that are related to preventing safety hazard, you're only talking about that clause and it requires necessity. Whereas if you're talking about non-safety hazard public interest issues, you're falling within the first clause.
So is this argument, what do you think our standard of review is? Well, let me suggest, I think our standard of review is whether there's substantial evidence to support that this is in the public interest. Have I got that wrong? You would say, no, it's substantial evidence that it's necessary for a safety hazard because you have to ignore the public interest language in this context?
Well, I think this is a legal interpretation of a regulation, so your review on legal questions is de novo.
And the legal question is de novo. So assuming we can get past the legal question of how these two clauses play into each other, Is it substantial evidence review as to
I-
whether it's satisfied?
I think determining whether or not the commission properly applied the waiver, that standard review is substantial evidence, whether there was substantial evidence to support issuing the waiver. My contention is that there was substantial, the evidence that's in the record did not support giving the waiver.
I thought we deferred to the commission's interpretation of its own regulations.
You do, but
You told us it was de novo a second ago.
it's de novo for legal questions, but if you're deferring to, I mean, you don't, the commission does not do any deference for an incorrect or an incorrect interpretation of a regulation or an unreasonable interpretation of the regulation.
But a reasonable one we deferred to, right?
In a reasonable one, yeah, you could refer to.
Okay. Trying to make sure I wasn't missing something.
I believe
I don't necessarily see the law the same way on this subject.
And I would say that the option to upgrade the cart path wasn't the least environmentally damaging alternative. It required significant work that would occur within the notice.
You said least damaging alternative, least damaging practicable
Correct.
alternative.
The alternative of using the existing driveway was practical and also had no impacts on the wetland, so it obviously has the least environmental damage. And then the other factors that the commission...
Is not giving the permit at all an alternative. It seems like you would think that alternative is you've got a public safety, you've got a public safety necessity, and you look at the various ways you can solve it by changes, and you pick the one that's least environmentally damaging. To say that leaving everything as it is an alternative seems to be like saying you're not meeting the original standard.
Well, if you're analyzing the alternatives, if you believe that there's some deficiency in the existing driveway, an alternative could be to upgrade that so it is sufficient for emergency vehicles, instead of upgrading the cart path, which has impacts within the no disturbed area. The second point I want to make for error is essentially that the Conservation Commission failed to confirm the wetland delineation along the stream. In the 2020 amendment proceeding, they were presented with evidence and testimony.
Can we just go back for a half sec? On the Cottage Way access, was any part of the work that would have to be done if you wanted to upgrade that, would any of that have been within the 50-foot NDA?
No.
Okay. Including as you get up close to the proposed septic?
Well, it's in the other direction from the septic. It's closer to the pond, but it's outside of the 50 feet from the pond, and I think it's outside of the 100 feet from the pond. But in any event, I believe it's outside of the 50 feet from the pond.
Your time has expired, but I'll give you just a minute to finish your thought that you were discussing.
Thank you. So before the 2020 amended order of condition proceeding, the commission was presented with evidence from Mr. McDonald's wetlands expert, Mr. Marcus, that there were errors in the wetland delineation.
Is that before the 2017 order of conditions was issued?
Yes. No, it was after. It was in 2020 during the amendment proceeding.
Okay.
So during the amendment proceeding, and this goes back to what the third argument is, the scope of what the commission reviews in the amendment. I would say the language in that one relates, the factors are the entire project, not just the requested changes. But the information before the commission was...
Does that argument mean that they would be obligated, as you read it, by their bylaw to, if there is any amendment, reconsider the entire project?
I think they need to consider the project as a whole, holistically, and whether or not...
So that by law, they would be required to look at everything. That's your position?
They would be required to make sure that the project as proposed to be amendment still, in its entirety, complies with the performance standards of the wetlands law.
Which would include having to take on additional evidence, right? I mean, this all comes down to whether they would be required to take on the additional evidence that you wanted to present regarding the delineation of the wetlands near the stream, right?
Right.
And your position, but see, the problem with that is that this process is supposed to be give and take, and adjustments are contemplated by the way we think that process is going to work. And if it's true, as you say, that every time you have an amendment, you basically go back to square one and restart.
But that's what the rule says. The rule says if you have an amendment that's large enough, you have to file a new notice of intent.
Large enough, exactly. And the standard of review of that is abuse of discretion?
I would suppose so, yes.
All right. You're going to have another chance, I think, to stand up, and I think this issue is going to recur, so.
So let me see if there are further questions on this. No.
Thank you.
We will see you again shortly. Well argued. Thank you. And I assume this is Attorney Costa.
Yes, good afternoon, members of the panel, and may it please the court. For the record, Adam Costa, I represent the co-defendant, KRISTEN Kazokas. The brief was submitted both by me and by counsel for the town, but counsel for the town is deferring the oral argument to me. If I could, Your Honors, where I'd like to begin, and largely in response to the questions that you asked of my brother, is with the language of the regulation, and specifically the language that addresses waivers. It is on page 23 of the record appendix, and it's actually crafted quite nicely because it's included with bullets and underlined phrases that highlight really one of the issues that is critical to your determination today.
Is this LWR section 1.41?
That's correct.
Okay, go ahead.
And so it is titled Waivers from Regulations, and it says, quote, strict compliance with these regulations may be waived when, in the judgment of the commission, such action is, and then it's followed by 3 bullet points. And within these bullet points, it uses the words or and. And in each instance, those words are underlined to highlight the requisite standard. So first bullet point is that the regulation can be waived when it is in the public interest, comma, necessary to avoid a taking, comma, necessary to prevent a hazard, comma, or is underlined, water dependent. Then it says and is underlined. Number 2, consistent with the intent and purpose of the bylaw. That one doesn't seem to be at issue in the current appeal. And then the word and appears again, and it's underlined, and it says the least environmentally damaging practicable alternative.
What do you draw from that? Okay, we can all read it.
Sure.
But what do you draw from that? What should we be focused on in your view?
Well, I think that for purposes of the appeal, we should be focused on 2 things. Number 1 is the first bullet point and the determination that was made both by the Conservation Commission and then subsequently by the trial court that the standard here, the determination that was made by the commission, was that a waiver of the regulation was in the public interest. The Conservation Commission did not speak to this question of whether it was necessary to prevent a safety hazard. It did address safety in the context of public interest, but the determination that was made, and it's quoted explicitly within the order of conditions, is that, quote, a waiver of the minimum NDA was in the public interest. That's on page 104 of the record. It's in the order of conditions. And that's the standard that was applied by the trial judge as well. The second thing that I read into section 1.4, and that's at issue in this litigation.
Say it's on 104 of the?
That's correct, page 104 of the record appendix, which is a
104 of the, so, hold on.
Correct. And that's just a portion of the order of conditions that was issued where that finding was made.
I think my copy ends on page 98. So there's an explicit finding, it's in the public interest?
There is, in the order of conditions. And so that's the standard that was applied, and that's the standard that was applied by the trial court judge. Now, again, there is some overlap here in the sense that in evaluating the public interest, you can look at such things as safety. And I go into some detail within my brief as to what's the definition of public interest. And the definition incorporates the concept of public welfare. And then I look to Black's Law Dictionary.
You're assuming that the way to read this is that each one of those is separate.
Well, it does use the term or.
Well, another way to read it might be that the 3 that follow it are defining the public interest.
Which 3 that follow it, Your Honor?
In other words, such action is in the public interest. Then I would be adding the words, that is, necessary to avoid a taking, necessary to prevent a safety hazard, or water dependent.
I would agree that if it said what you just quoted, that is how I would read it. But it doesn't say that. It uses commas to separate 4 separate items, and it uses the word in between the 3rd and the 4th item in that list, and underlines the word or, and it uses the Oxford comma. to separate them. So I do read it as individual, and certainly there's no question here. And in fact, if that were the case, I would imagine my brother would have also argued in his appeal that there was no finding that this was necessary to avoid a taking, that there was no finding that this was water dependent, which of course it's not, because those aren't requisite findings that the Conservation Commission has to make. And as was referenced before,
No, that's not my point. No, it could be any one of the later three, but because public interest sort of, it's an odd phrasing, right? I mean,
Agreed.
they may waive these regulations when necessary to avoid a taking. No, they actually have to waive them if it's necessary to avoid a taking. It's sort of an odd, and one would think if there's a safety hazard involved, you can't like decide you're not going to waive them. But you say, anyway, in the public interest, stands by itself, and they made a finding to that effect. And then Justice Ditkoff would say, well, reasonably defer to a reasonable construction of their own regulation, and that would be the end of it.
I probably would say that.
And if I can add something, Your Honors, and at the risk of sort of beating a dead horse here, let's say you're correct, and that the commission was obligated to consider whether there was a safety hazard. I believe they satisfied that standard anyway, and I was fearful. You commented to my brother that maybe the two versions of briefs that were submitted were distorting the facts a bit. I certainly that wasn't my intent. In fact, I thought I was overusing the block quotes here because I was trying to give you excerpts from the Conservation Commission's order of conditions, from its transcript, things commissioner said, things the fire chief that said, things Mr. Peter Trapiano, the immediate neighbor, said. So I provided all those quotes.
In his brief, he said, what you're quoting from is actually testimony describing the road coming from Shagbark Lane. Okay, that's what his brief says. And I went back and read the stuff, and I gotta tell you, it isn't that easy to figure out who's saying what. And what they're talking about. And that's why I had difficulty sort of reconciling the factual assertions in the two briefs.
That's fair. I've read through the transcripts as well, and it's...
Is the strongest evidence in this transcript for the status of Cottage Way the language that I read?
Well, Your Honor, respectfully, I don't know what language you read.
Oh, I mean, geez, I would have thought... It was from the chief's testimony at I think it's like a July 2017 hearing, where the question is asked, would you need to get access on Cottage Way? We would have to get smaller. We would have to get smaller engines down there. We wouldn't be able to. It would be a little bit more of a challenge to get some of the other apparatus in.
It is, and to your point,
that's the strongest.
It is, and
as to what Cottage Way's status is.
Yes, maybe paired with the comments made by Peter Trapiano, which I think my brother is misconstruing to suggest
about the 8 or 9
and the culvert that prevents the access, and it's a blockage for her. He didn't say it's a blockage for us, which he obviously would have said if it was a blockage for them both. He said it's a blockage for her, but that statement was taken out of context. What's also important, and I quote this on page 32 of my brief, there was a back and forth between Stephen Erickson, who was then the wetlands consultant to that one meeting representing the McDonald's, and the fire chief. And the fire chief responded unwaveringly, is the word I use here in my brief, and he said, and this is a direct quote, I looked at both of them, talking about the access from Cottage Way versus the access from Shagbark down what's been referred to as the cart path. He said, I looked at both of them. The best access is going to be from the top, is having the adjustment to the existing driveway. So he makes it very clear, and then of course he goes on to describe the width he needs, 12 feet.
That's a relative statement. That doesn't tell us the status of Cottage Way then, right? That's a comparative statement by a fire chief who's talking about what's the best way for me to get in. Part of it, which I took from the reading, was that it's just faster to come up Shagbark Lane for him.
Well, I think we have to remember, Shagbark Lane is an elevated roadway that is a distance from Fort Bond. It is a paved roadway. Thus, it is graded, it is flat. It is the means of access, in fact, to the McDonald's home at the end of Shagbark Drive. Cottage Way is an old, historic, unpaved roadway. It is gutted, it is hilly, it has rises and dips. I've driven down it myself. I nearly bottomed out in my sedan. So it's a sedan, not a, right?
That's not in the record
Gotta stick
before
to
us,
the
so
record.
don't do that.
That's fair. So it's a challenging roadway. It's unpaved. That is in the record that it's an unpaved roadway that is in close proximity to Fort Pond comparatively. So it's a challenging roadway. I believe that the reason I pointed out that statement, that back and forth between the fire chief and Mr. Erickson, was not so much because it wasn't comparative, but because I think read in context with the other statements that are made by the fire chief, it provides some description as to what he's referring to when he says that the condition is poor, that the proposed improvements are necessary. You suggested there was some confusion. Is he talking about Cottage Way, or is he talking about the cart path, the access via the driveway down from Shag Park? I think he's talking about Cottage Way when he talks about the poor access to the site for fire and emergency purposes.
So let's move on to waiver in the context of the third prong, the least environmentally damaging practicable alternative.
Sure.
How were the actions here the least environmentally damaging practicable alternative?
Well, a couple of ways. And so the allegations my brother makes...
Tell me with great specificity, please. This
Sure.
is important to me, at least. I can't speak for my colleagues.
So number one, the continued use of Cottage Way, which would be an alternative, correct? That would be arguably less environmentally harmful.
Less or least?
Say that again, Your Honor?
Less or least?
I think my brother would argue that it was less, maybe not least, but it would be less. I would disagree with that. He made statements about the proximity of Cottage Way to Fort Pond. It is in much closer proximity, certainly, than Shag Park, and in closer proximity to the majority of the driveway that is proposed to be improved coming from Shag Park. But there was extensive discussion that appears in the record, and on page 34 of my brief, I cite to 1, 2, 3, 4, 5, 6, 7 different pages of the record where there is an extensive discussion by the Conservation Commission about continued use of Cottage Way as an alternative. Moving on from that, there's then also a discussion about, well, what about adjusting the driveway? And if Your Honors look to the plan of record, which is included in the appendix, it is page 259. That's probably the best visual.
Volume 1 or 2?
Say that again, Your Honor?
Volume 1 or 2?
Volume 1.
And page, I'm sorry, what page?
259.
Thank you.
You can see the location of the proposed driveway improvements as it relates to the 50-foot wetland buffer and the 100-foot wetland buffer. And so there was some testimony that was provided that even if the improvements were to be made on the opposite side of the driveway.
RA2, Volume 2, page 259.
I'm sorry, I thought it was 1, Your Honor.
Is incorrect. So Volume 1. Thank you. Sorry.
That's okay.
Volume 1's only 225
pages, so I'm not with you.
I don't think your 104 was right either.
Well, I apologize, Your Honor. I have it as record appendix, page 259. It's the plan of record. It's called the scope of work plan. It was a large-scale plan, color plan, and your copy, mine is black and white, but it shows, it's the plan that was submitted by Ms. Kazokas to the Conservation Commission. It's the plan that's been at issue in these proceedings, and it shows the location of the proposed driveway improvements as well as the septic improvements and the cottage expansion, and it shows the work that is including
I'm
within
sorry
that.
to do this, but can we just have that handed up for one moment so I can take a quick look at it? Because
Want to make sure we're on the same page.
literally. Oh, okay.
I see it.
So I have this, I think. I'm pretty sure I have.
I've seen that.
I have two. Just what page is it on? It's not
What does it actually say?
197.
RA 259 is what it
Oh,
says.
59, not
But
150.
there's no, it just got switched into two volumes.
No,
so
RA 259.
This is something different.
This is from an old,
Okay.
thank you.
And we'll give you an additional minute. Don't worry, counsel.
Thank you. So, Your Honors, there was testimony that was provided by the applicant, and I'm quoting from page 35 of my brief, that widening the cart path on the other side from the wetlands would require more ledge and tree removal, as that side of the access way is at the top of a steep slope. It's a steep grade with ledge outcropping. If we start cutting away on that, that's a lot more work and a lot more equipment than is necessary.
What are you reading from there?
This is testimony that was provided during the Conservation Commission proceedings by the applicant.
Okay.
There was then a determination, a finding, one of the commissioners commented, quote, "There's not much room on the other side of the driveway to expand." The bottom line is if there were to be an expansion on the other side of the driveway, it's still within the 50-foot NDA. So it's not lessening the effects. It's at least equal, and in the testimony of the applicant, it is far worse because you're digging further into a slope. And in fact, Judge Wall made that finding in his decision where he said, quote, "This alternative would impinge more upon the
Judge
structure."
Wall take a view?
He did not. It was a motion for judgment on the pleadings under.
Judge Barrett take a view? Did Judge Barrett take a view?
No. Both proceedings were under Standing Order 196, so there was no view in either instance. Your Honors, I'd like to speak briefly, if I could, about the second argument, I suppose, that my brother advanced, which is this idea of reviewing the entire project in 2020. So the application that was made in 2020 was an application to amend the order of conditions. The regulations that I previously made reference to that are in the record include language that is very similar to DEP's Wetlands Program Policy 85-4, which I've cited in my brief. In fact, it's almost verbatim, the same criteria that are required under that policy. The idea being that there's a streamlined or quicker procedure to obtain minor adjustments that don't change the purpose of the project or expand the scope of the project or have any greater potential for adverse impacts to protected statutory interests, and allows the commission to make that determination and therefore to allow an amendment. And that was the application that was made. Our position is that the commission rightly determined that it should not expand its scope of review to other aspects of the project. The sole purpose of that amendment was to eliminate a portion of the cottage that had become located within the 50-foot no disturb area as a consequence of the OADR proceedings you're going to hear a bit more about momentarily. I'm over my time.
Questions? Nope, seeing none. Well argued by both counsel.
Thank you.
The case is submitted. And calling our final case on the list today. Sixth case is docket 24P923, again McDonald versus Kazokas. And we will hear first from counsel for the appellant. Good afternoon again, counsel.
Good afternoon again. Peter Viteri from Beryl Dana on behalf of Ken and Jody McDonald. This is the State Wetlands Act DEP part of the appeal, separate from the Town of Littleton appeal. Essentially, there's a similar issue that was raised in the local appeal, but it's about the failure to delineate the wetland area that was identified by Mr. McDonald's wetlands consultant. I'm going to run through a sort of a chronology here and tell you what's significant here. So in June of 2018, the presiding officer of the Office of Appeals and Dispute Resolution of the Department of Environmental Protection, OADR, ruled that the wetlands delineation was not an issue for adjudication in the adjudicatory proceeding. In July of 2018, Mr. Marcus submitted his pre-filed testimony where he identified 3 wetlands errors that were on the applicant's plan. And then in August of 2018, the applicant's wetlands consultant, Mr. Cowell, revised the plan but only incorporated one of those errors that Mr. Marcus identified, the one of wetlands that were next to the pond. At this point, the DEP, during the adjudicatory proceeding, had conceded that wetlands delineation had become an issue, and the presiding officer ordered or gave an order or the DEP requested a site visit, and the presiding officer allowed the parties to have a site visit to check the wetlands delineation, but the OADR limited that wetlands visit and the site visit and the delineation.
Why was that an abuse of discretion?
It's an abuse of discretion because once one wetlands
Of the standard of review, right? Abuse of discretion, right?
That's correct.
Okay. Why was it an abuse of discretion?
Well, it's arbitrary and capricious, but abuse of discretion, but I think there's overlap there.
Okay, okay, fine.
But it was because once the one wetland error was identified and then corrected by the applicant, so verified to be correct and in error, it was arbitrary and capricious for the presiding officer to not go and check the other 2 wetlands errors to make sure that they were correct.
Well, you call them errors.
Mr. Marcus called them errors.
Yeah, but we don't know they're errors.
Well, that's why you check. Again.
But nothing requires that, does it?
Well,
what requires that? I mean, they amended they decided they wanted to amend their wetlands delineation near the pond. For whatever reason, that turned out to be something that required a change. Required may be too strong a word, but caused them to change the house to be of a lesser footprint, right? A material change that made it a lesser footprint. And that's what they submitted an amendment to that effect. Why does anything further have to be amended?
First of all, it is the applicant that only chose to amend based on one of the identified errors.
Well, no, see, you keep acting like Marcus is the be-all and end-all, but he's not. The applicant controls what their proposal is. They had a proposal out there. You had not raised delineation of wetlands whatsoever. Your chronology starts in June of 2018, but the chronology really starts much earlier than that when you noticed your appeal and didn't raise this issue, right? You didn't raise the issue. You didn't raise the issue when you went to the preliminary conference. The judge was trying to have a hearing. She couldn't have the hearing because you kept trying to add things to it, and that got added. But they control what it is they do, don't they? I don't understand why they have to respond to Marcus.
Because Marcus raises credible evidence of an error in the wetlands delineation and the wetlands
Even
regulations.
let's assume that's correct.
Okay.
Why do they have to respond to that at that point? Procedurally, is it an abuse of discretion for them to conclude that you'd waived that issue? You waived that issue 6 months ago.
Well, if 6 months ago in February of 2018 was all that the adjudicatory proceeding was, maybe that's the end of the story. But they brought the issue back into the case, into the appeal.
They brought into the case the issues they chose to, which had to do with redoing the wetlands delineation near the pond.
And there was credible evidence of other errors. And the regulations at section 310 CMR 1055 2C2, I believe is the citation, says that when credible evidence is presented to the issuing authority must evaluate the wetland delineation.
No matter when?
Yeah, no matter when. It can be raised.
No matter when. So that means that you failing to do what you were procedurally obligated to do is irrelevant because you've decided that later on you're going to find an expert and he's going to say something different and you are obligated to address it. How can that possibly be a procedure by which we would go?
Because the applicant brought it in.
It can't be that it can be continually reopened. One of the biggest problems with this, for me, is that this started 8 years ago. We can't have processes that can continue to be reopened and delayed. That's what you're arguing. You are arguing that if you bring a credible argument, no matter when you were supposed to bring it, it has to reopen the procedure. What am I missing?
The department itself, who is the issuing authority, because they issued a superseding order, they are the issuing authority. They are the ones who reopened the issue of the delineation.
Department said the 100 flags and the 200 flags had to be reevaluated. And everyone agrees on that, because everyone agreed they were wrong. Why does that mean all the flags are wrong?
Well, Marcus identified errors in the other flags.
Marcus did, but Cowell and Goddard say there's nothing wrong with any other flags. In fact, Marcus doesn't have worksheets and couldn't possibly have made the observations that he did. So why can't a reasonable commission say, okay, let's revisit the ones everyone agrees are wrong and the other ones that weren't part of the notice of appeal, we're not going to revisit.
Well, Cowell says that they were wrong. He says they were only wrong by 1 to 2 feet, and Marcus says they were wrong by 8 to 12 feet. So they both agree that there was an error somewhere. It's up to the issuing authority, the DEP, and it was in front of the OADR, so that the presiding officer is allowing another site visit to delineate some of the wetlands that are in error. He should be allowing everybody to go and delineate all of them.
Use the word should, but that's not what you mean. What you mean is he's obligated to.
They are obligated, because 1055 says must. So it is an obligation. And what Marcus provided was also photographs of salamander eggs.
Regardless of whether or not you complied with the procedure in the first place for the delineation of issues?
But that wasn't the end of the procedure. The process went on into August, and the DEP...
I understand. I don't mean to argue with you, and I know I am.
But the difficulty I have is what I said, which if the logical extension of the argument you're making is that you can at any time raise new issues with respect to something like this, the delineation of wetlands, and by doing so, delay the adjudication and the conclusion of the dispute.
I mean, it was the DEP that wanted the site visit. So the DEP agreed to any delay.
DEP wanted a site visit to confirm what the applicant had decided to change. The applicant, I'm assuming the applicant didn't object to the DEP coming on for that purpose.
Well, the presiding officer limited what they could investigate at the site visit.
Right.
Right. I mean, the applicant's
discretion.
The applicant is omitting those things. Maybe there's a reason for the applicant to be omitting the other errors because it changes the project around a lot more.
Maybe the reason is as simple as there is no other error.
Well,
The person had actually gone out, taken a look at that, and he decided it was off by a foot, which made no difference to anything.
1 to 2 feet, and Mr. Marcus said 8 to 12 feet, so it's somewhere in between it, and it's worth investigating if both of them say that there's an error.
Why does it have to be somewhere in between?
It could be. I mean, who knows? Nobody checked. Is the point.
Couldn't you just credit Cal's testimony if you're an OADR officer?
I mean, you could credit Cal's testimony, but you have 2 experts that agree that there's an error. So why would you, the abuse of discretion or the arbitrary and capriciousness of it is not checking the error when both experts agree that there's an error in the delineation.
I thought there was a conclusion by Cal that the flag that was closest to the septic system was right, correct, not an error at all.
He said flag number 4, which was the one that's closest to the septic system, was 1 to 2 feet off. And Mr. Marcus said it was 8 to 12 feet off. And Mr. Marcus had measured from the other property.
At a single isolated location between wetland flags number 2 and number 3, I found there to be a negligible discrepancy. Where did he say flag 4?
I believe 4 is what it was in there. My recollection.
Tell me where in the record, because I just read you what's in Appendix 2, page 158.
Well, I don't have it in front of me, but my recollection is it's wetland 4 that was.
I can tell you that once again we have ships passing in the night, because I read their brief last night, and it says that the flag closest to the septic system was not changed. So either they're right or you're right. So here we are in the same situation that I was worried about with respect to the road.
I think the issue is whether or not when you have experts that say that there are errors and you have credible evidence presented, the issuing authority, the DEP, is obligated to go and delineate those wetlands and identify what is the correct wetland delineation. The second argument we make is an abuse of discretion by the presiding officer in different procedural aspects of it. First off is the wetlands delineation issue and not addressing that or allowing or limiting the scope of what the parties could investigate. And the second is the determination that there was no unpermitted work that was done in violation of the superseding order of conditions. The superseding order of conditions itself and the regulations say that no work shall be done until an administrative appeal is concluded, essentially. And it's clear, obviously, that work was done before this appeal is over.
Did you have a question?
I did, but you can go.
No, you go.
So where all that work was done would be DEP and the commission being informed and saying it was okay. Why would that be a basis for revoking the permit?
Well, so one condition was that the EP had to be informed before any work occurred. And the other condition was that no work is supposed to occur.
Right, but so an applicant says to DEP and the commission, I'm going to do this work that's outside the buffer zone. And they say, go ahead. So why would that be a basis for revoking the permit?
Well, first of all, it was Mr. McDonald that reported that the work was being done. Second of all, the DEP's interpretation of the work being done is incorrect. They said that it's because it was quote-unquote minor activities.
I understand you think DEP should have said, no, you can't do anything, even outside the buffer zone, until McDonald's appeal's over. That's not what they did. They said, go ahead. So why would that be a basis for revoking the... how could it be even rational, never mind required, to revoke the basis on the fact that someone did what the commission and DEP told them they could do in the meantime?
Well, because the DEP was wrong. Because they said you can do minor activities in the buffer zone, but you can't do minor activities in the buffer zone under the regulations. You can't do any work under the jurisdiction of the Conservation Commission or the issuing authority until the administrative appeal is concluded. And there was work done during the administrative appeal. And the superseding order of conditions itself
Says
has
that,
to...
what are you citing that says you can't do any work at all in the buffer zone, if it's unrelated to the issues before the Conservation Commission or the DEP?
It's a condition in the superseding order of conditions. It's also stated in the regulations at 1005, I believe. I don't have the exact citation in front of me.
Any work in any buffer zone on the property? Is that
Any work the proposed work that's approved under the order of conditions, the superseding order.
Oh, I see. Any of the proposed work.
See, the minor activities provision is a preliminary provision for if you're going for a different determination of applicability, a request, an RDA. It's basically a lesser permitting vehicle than the notice of intent.
Let me try again. So let's assume there's a violation. Why is the result of that violation that the permit has to be revoked?
Because, well, if it's unpermitted...
What says that?
Because you're trying to wait until the appeal is completed. If the appeal is completed and, for example, the superseding order of conditions is annulled and vacated, then you don't have permission to perform that work. So the work that you've done should have to be reversed because you never had permission to do it in the first place.
No, it's absolutely true, but that's not what happened. The permit got affirmed. So why does a commissioner who's decided that this permit is fine, and everything that's being done is fine, have to revoke the permit that he's decided is fine because there was work that they were allowed to do by the commission in the meantime? What says that?
Because it's under appeal, and you can't do any work until the appeal is over.
What says if you do any work while it's under appeal, you lose the permit even though it's an okay permit?
Well, the presiding officer said that that's a conclusion, but it says that a condition is no work shall be done until the appeal is concluded. I suppose,
I'll try one more time. Is there a regulation or a case or anything that says that the result of doing work is that your otherwise valid permit has to be denied?
Well, what's the alternative if your permit is ultimately annulled on the appeal? Then you've got work that's completed that was never approved. So otherwise, you just get away with that?
Is that a complicated way of telling me you're not aware of any such regulation?
I'm not aware of any such, but I'm playing out the rest of it. I mean, what's the consequence of doing work while an appeal is pending, and then the appeal comes back and your permission to do that work is revoked, and that work is already done? What's the remedy for that? The remedy should be...
Wouldn't you have to fix it? Undo all your work at that point?
I believe so. I believe that's the rationale for prohibiting that work to be done in the first place.
Any further questions? No.
I had one question, but and it's this. You say in your briefs that they took down trees that were 75 feet tall. Where was the evidence of that?
There's photographs that Mr. McDonald submitted that show photographs of the trees before they were taken down. And then Mr. McDonald submitted a letter to the commission asserting that.
Okay, so there was an assertion that happened, and then there's a conclusion by the DEP consultant that no trees were stumped. And that is accepted by by DEP, right?
Right. Well, no trees were stumped doesn't mean trees weren't taken down. It just means the stumps weren't pulled. Trees could be lopped off and the stump left, and that's the rationale for DEP saying there was no work done. But the work definition that is cited by the department is that includes destruction of plant material. Cutting down a tree is destroying plant material even if you don't remove the stump.
I assume there was nothing in the record where anyone agreed that 75-foot trees were cut.
I don't think there's anything in the record that says that that's not true. I think the applicant and DEP acknowledged that trees were cut down. Whether they were 75 feet tall or not, I mean, there's no height requirement for work being done.
And we're going to have to leave it there.
Thank you.
Thank you, counsel. We will now hear from the Appellees, first, we will hear from the Department of Environmental Protection, Attorney Cousins.
That's right. Thank you, Your Honors. Carlos Cousins for the Department of Environmental Protection.
Good afternoon.
Your Honors, the Superior Court correctly affirmed the Department's determination that the SOC, or superseding order of conditions, satisfies the requirements of the Act by protecting Commonwealth wetlands. And this is the Act at Chapter 131, Section 40, and implementing regulations.
I'm going to ask you just to slow down just a little. I know you have a lot to get through, but just slow down a little bit, please.
Yes, Your Honor. And implementing regulations, including 310 CMR at Section 1053.1. As you know the facts, I will go ahead and begin responding to some of the arguments raised by opposing counsel today. The first regarding the denial of the motion to compel a site visit after or during discovery. That denial was proper where the issue was not raised for appeal to the OADR. Although that issue had been raised in earlier proceedings, the notice of appeal did not list it as one of the issues for.
So I think we've got this up to the point that he started talking about the chronology. So I think we understand the chronology up to June of 2018. And understand that there's a very strong, in my view, maybe not, waiver argument that comes out of what happened up till then. But your brother says, wait a second, everything changed because there was an amendment filed by the applicant, and DEP then says, we want to get on the site to look at whether wetlands have been properly delineated. And your brother says, when that happened, the rules, the regulations say there was an obligation to also consider other contentions as to the delineation of the wetlands. What do you say to that?
I say that there was no obligation here, that the department acted reasonably in going out of its way to ensure that the delineations were properly made and represented to it.
He says you have an obligation under 1055 C2.
2C2.
2C2 to, when credible evidence has been presented to you, that there's an issue with encroachment on wetlands, right?
That's right, but no credible evidence was presented here. There had been
no credible evidence. The guy was right about the other problem. He says that I think that you're off by 8 to 12 feet, right?
But this discrepancy would not have affected the 100-foot buffer from this inland bank in the intermittent stream. So it would not have affected the area in which activity or work would be performed.
My understanding is that if Mr. Marcus was correct about the discrepancy and the alleged discrepancy with respect to the delineated wetlands next to the stream, that it would fall then within 50 feet of the septic system.
But that issue is not before the department here under this.
That's the question. So there becomes evidence that some of the wetland delineation is wrong. And so everyone agrees at least part of it needs to be checked out in person. So why is it rational, reasonable to say, but we're going to ignore everything else?
So the 50-foot requirement, I believe, comes from the bylaws. What was at issue here was...
Oh, the 50-foot requirement comes from Title V,
Yes.
which says you cannot put a septic system within 50 feet of a wetland.
My apologies, Your Honor. Yes, Title V, which was not the issue here, which has to do with the 100-foot buffer under the Act. And there's a presumption that applies where the National Board of Health, I believe was, in interpreting Title V, found that the septic system complied with all requirements of Title V that needed to be overcome. That the presumption is that the septic system furthers the objects or the interest protected by the Act.
You know the record. Can you tell me, and I probably should know the answer to this, but the argument that was made
how was the argument presented that once there was an adjustment to, there was an amendment, once the amendment was presented by the homeowner, and there was an adjustment, how was the argument made on the other side that you ought to be looking at the changes to the wetland that were near the stream? Did they say, you need to look at these as well because there will be a Title V problem?
I don't believe that that's what was said, Your Honor, but I don't want to say an absolute answer where I may have missed any argument to that effect. I do believe that they insisted that all of the wetland delineations should be revisited, in part by citation not only to the opinion of their expert, but also to representations from experts for the department and the landowner.
Correct me if I'm wrong, because I'm not an environmental guy, but I got the impression from both of these cases that you can send your wetland experts, and if they're on the land, it's not very hard, not very time-consuming to delineate if you're on the property. And if that's true, and correct me if I'm wrong, I'm struggling to understand why it's rational to send Selby and everyone else out there and tell them, well, only look at these. I mean, why wouldn't you have them look at everything while they're already out? I could see why you wouldn't want to do that in the first place, but once you decide everyone's coming out to the property, where's the rationality in saying, but only look at one part?
I can't comment on how long that would take or how time-intensive it is, but I can say that it was a reasonable decision among the decisions available to OADR here to say where these are delineations that it seems the parties are agreeing are at issue, we should ensure that they are representative of the actual delineation near the pond, but where the issue of these additional flags being sought to be revisited was not properly raised by the plaintiff in the matter, and where there was no indication justifying good cause to amend the issues before it, and that's the standard that the presiding officer shall, absent good cause shown, limit the issues for adjudication to the issues identified. This is in the notice of appeal, and then identified at the pre-screening conference. This is from 310 CMR 1016K. There was no good cause to go beyond that, shown that issue was not one that would be revisited at that time. At the time that the motion to compel the site visit was made, there was a judgment made based on what evidence was presented then. When we had the affidavit of PWS Marcus, which had made general representations that he believed it would be necessary and what have you, but there was no analysis as to why, or any identification of evidence as to why that motion should be.
So that's an answer to the question I asked, okay? If all you have is general statements that I think that you need to look at this, and you don't have someone saying, by the way, based on Marcus's new delineation, you've got a Title V problem with respect to the septic system. If that wasn't argued, that's, at least to me, a point that I'm interested in.
I understand.
We can take a look.
I understand.
Okay.
To respond to the additional arguments of opposing counsel regarding the tree limbing and cutting, when that issue was raised, the department thought to send PWS the department analyst Selby to the site to observe and ensure that no work had been performed.
She says no trees were stumped. I read that to mean there were no stumps. In other words, no trees had been cut. Did I misunderstand that?
She said that there was tree cutting and limbing, but right, no stumping.
What is, if there was tree cutting, what does that mean?
Well,
trees were taken down?
Work under 310 CMR 1004, and no trees were taken down, defines work to include a number of activities which alter the site. It says things like destruction of plant life, changes to the characteristics of the land.
Cutting down a 75-foot tree
But there was no cutting.
strikes me as destruction of plant life.
What she determined was that there was vegetation cutting to maintain visibility of road signs and protect drivers and things which were exempted from the regulation as minor activity. This is 310 CMR 1002B2 MNP.
Nothing.
Okay, thank you very much, counsel.
Thank you.
Appreciate your argument. We will now hear again from Attorney Costa. Good afternoon again.
Good afternoon again, and for the record, Adam Costa representing the private defendant, KRISTEN Kazokas. If the court wants to direct me to specific issues, I'm happy to answer questions, but I can also address 2 points that I think might warrant some further
Why don't you
discussion.
start with your 2 points, Mr. Costa?
Be happy to. So first, let's talk about this delineation and the 8 to 12-foot discrepancy that's been referenced, because it's really not a discrepancy at all. Mr. Marcus never had access to the property. He never performed a wetlands delineation, to be clear. That appears in the record. In fact, there's a description, a lengthy description by David Cowell, who is representing Ms. Kazokas as one of her 3 experts, who explains that Mr. Marcus performed observations on February 14th of 2018 during unfavorable winter conditions. These were performed from a distance of no less than 29.9 feet away. And he concludes that based upon these mere observations, no delineation could have been accurate in the first place. Second of all, with respect to the edge of pond and the delineation that was apparently an error, I think it's been referred to by at least one justice as an error that Mr. Marcus caught, and if he caught that error, shouldn't the other errors that he alleged be looked at? It really wasn't an error at all. What had happened is the edge of pond was never field delineated. We didn't ever argue that it was field delineated. It had been survey located based upon the mean historic high water level. That's all that had been done. In response to the pre-filed testimony of Mr. Marcus, which highlighted the fact that it had never been field delineated, and I guess you can file this under the category of no good deed goes unpunished, Ms. Kazokas, in consultation—
I would agree with that.
Yes. Ms. Kazokas, in consultation with her consultants and counsel, decided that it would make sense to field delineate. Bottom line, glad we did, because the field delineation brought the edge of pond, actually field delineated a bit closer to the project, and that affected the location of the expansion of the cottage. And so that was discussed in the prior docket, prior case where the cottage footprint was reduced because it moved that local 50-foot no disturb area closer to the cottage.
I mean, we should all want to keep the cottage 50 feet away, right?
Correct.
I mean,
We want to keep it 50 feet away.
I mean, I think that's something we all want.
Correct. And so we've done that, and that was, again, that's a local
What
requirement.
about the stream and its relationship to the septic system?
So portions of the septic system are in proximity to the stream. Portions are outside. And this actually goes to the enforcement question as well, because there are these generic statements that are made about—
Weren't there flags? Wasn't there a delineation of the wetlands with respect to the stream?
There was. And so
Okay, and your guy, under the no good deeds theory that you just spun out, went out and took a look, and he decided there was a discrepancy in one place of 1 to 2 feet between flags 2 and 3, but the closest flag was flag 4.
Correct.
So there was no adjustment with respect to the flag that was closest to the septic system, which I think was 54 feet away from the closest point of the septic system.
That's correct. And in fact, the septic system, the Title V matter, the Title V permit that issued by the Board of Health was also appealed by the McDonald's. It was also litigated through the Superior Court. It was also brought to this court. It was also decided about 1.5 years ago in favor of Ms. Kazokas and the Littleton Board of Health. So that case has been litigated. That case is closed. There was no further appeal or further application for review by the Supreme Judicial Court. But to your point, that's correct. Wetlands flag 4, and this appears on page 39 of my brief. It also appears in volume 2, page 157 of the record appendix. The closest flag was flag 4, and Mr. Cowell found no discrepancy with respect to flag 4. I want to address in the limited time that I have this question of enforcement and the work that was done on the property. There's a relationship between the work that one might be able to do on his or her own property without even making application to a Conservation Commission, and work that would either require the blessing of a Conservation Commission or, in some instances, the issuance of an order of conditions, or in the event that it's further appealed, the superseding order of conditions by the DEP. It was determined, and again, this appears in the record, appears in volume 3, page 126, and page 350, 2 separate sections of the record. In the first instance, Denise Child, who's the section chief for the Central Regional Office, advised Mr. McDonald, and she testified as much, that this could qualify as a minor activity under the regulations. And then Megan Selby, the DEP environmental analyst, who provided pre-filed testimony and subjected herself to direct or cross-examination, during the OADR proceedings, testified that, quote, the work that KRISTEN did, while included in her scope of work and description, could also be done without a permit. So this is a large site. There are portions of work that are done entirely outside of the 100-foot jurisdictional bounds of the Conservation Commission and the Wetlands Protection Act. Even since this case was filed, there has been a well installed on the site. There have been some
Because
components.
it's outside 100 feet.
That's correct. And so there has been some work done on the property. That work was either outside the 100 feet or to the extent it was within the 100 feet, it was determined in consultation with representatives of DEP and the local conservation agent that that work was permitted.
Anything further? No.
Thank you very much.
We appreciate your arguments. These are extraordinarily, and this is an extraordinarily comprehensive case involving a large record. We appreciate the arguments of counsel. We will continue to sort through it, and the case is submitted. Thank you. And that concludes our sitting for today. Thank you to the clerks and court officers.